Good morning, good morning, good morning. It's Friday. It's January 31st. I always look at my phone to make sure I have the actual right date, but it's January 31st, 2025. We are going to court today in Massachusetts for a number of motions hearings, including the hearing regarding the defense tech expert. The prosecution made a motion to exclude. We're going to talk about that because it's like a motion to have a motion. And so we're going to go through all of the emotions of all of these motions in Massachusetts. And because that's where we're headed, we should just really, get right into it. So I'm going to roll the intro. We're going to do a road so far, and then we are going to zoom into court. So intro, road so far, zoom. Let's go.
Hey there, I'm Emily D. Baker, the internet's go-to legal analyst, breaking down the legal side of the pop culture and entertainment stories we can't stop talking about. I'm a big fan of the cursey words. I've been a licensed attorney for over 17 years, but this is not legal advice. This is where the law nerds unite to talk about facts, not. Let's get into it.
You guys, I don't know what happened this morning. It took like 100 years for the stream to go live. We were trying to find a stream with closed captioning and had technical difficulties doing that this morning. So we're going to roll with literally the best that we have. But I know that most of you have closed captioning natively on your device. So if you can throw those on, that should work. But let's do a quick road so far, shall we? We are today going through numerous motions. I watched the judge call the case to order. They started late, and then we started late to give us zoom room. So we have room to hear some of the earlier arguments at a little bit sped up, which is going to be lovely. Today, one of the main motions is regarding the defense tech expert. The prosecution made a motion titled, wait, let me pull it up. I have to have the exact title because the shade. It is just absolutely wild that the Commonwealth's motion is the Commonwealth's motion to exclude defense witness Richard Green's debunked opinions. Yes, they put opinions in quotations, opinions. That's the Commonwealth's motion. The defense had much to say about this motion. The prosecution is asking for a Daubert-Lanigan hearing. We saw that with Dr. Marie Russell. Dr. Marie Russell has testified as an expert in courts, but not on whether or not something is caused by a different mechanism or a dog. And so her opinions were being challenged as to whether or not they were based on essentially scientific sufficiency and whether or not determining that the injuries to the victim's arm were caused by a dog or caused by a vehicle, and really exploring and testing that. And the court ultimately ruled that she was going to be allowed to testify and was going to be allowed to testify that those were from a dog and not a vehicle. And her testimony had come in at the first trial. This expert had come in at the first trial, but this is a different situation than Dr. Russell. Though Dr. Russell is eminently well qualified and has done lots of things, the area that she was seeking to give opinion in, A, is not as well established, and B, she had never testified as an expert in that area before. So while it might feel like that motion is a little bit picky for the prosecution, it's the proper grounds, at least for a motion like that, because testing the scientific validity or sufficiency of a thing is really what those motions are for. Hey, how do you determine this? How do you know this? What is the methodology you use to say that's from a animal and not from a car? And what does that look like? And can you explain it more? So that's a bit different. The tech expert, is coming and saying, hey, I ran a, forensic extraction on a hard drive or a thumb drive or whatever type of writable media. I ran a forensic extraction. And with that forensic extraction, I then took these other tools that all the forensic experts have access to and use. And there's a number of different ones. And I took these different tools. And with these different tools, I came to some conclusions. Now, the Commonwealth is saying those are debunked opinions, but a difference of opinion is exactly what the the battle of the experts is for. My brain just buffered because it's not what a Dauber motion is for. The prosecution really wants to go through this expert did not use a proper scientific foundation, and therefore this expert should be excluded. But you don't exclude a expert because your expert's opinion differ. So the prosecution asking to have that Daubert-Lanigan hearing, and in Massachusetts, the case that takes Daubert into the courts is Lanigan, but it's same. The Commonwealth is asking the court to have that hearing or to exclude the tech expert Green. But they are trying to say, look, he misinterpreted the data. Well, that's cross-examination. That's what an expert battle is for. And they are saying the reason Green should be excluded is because Celebrate, the program, changed, and therefore the Commonwealth experts are correct and the defense experts are wrong. Well, that's what a battle of the experts is for. That's not what a methodology hearing is for. So one of the motions that the court is taking up today is whether or not there will be a Daubert-Lanigan hearing with regard to Green next week. So the court has set aside time for that if it's needed. So one of the things on calendar today is the court saying, do we need to have that hearing? Do we not need to have that hearing? And we heard about Celebrate changing in the last trial. I went back and looked at my notes, and you can go back and watch the hearing testimony. The Celebrate guy said that this all changed because they believe it's a misinterpretation. It's up for the jury to decide whose interpretation is correct. It doesn't mean it's not a scientific process to take Celebrate and Axiom and other tools and look at them all together and come to a conclusion. That's not what that's for. So I don't find the request for a Lanigan hearing as to this expert well taken, but we will see what the judge decides to do. She's not going to do anything today. Everything goes under submission with this court. So we're not going to get there today. We'll see the arguments of the attorneys. And the judge indicated she would take up the defense motion for costs before the end of the hearing today. How long will today's hearing go? I do not know. But are we here? Yep, we're here. Law nerds were like,
bring the jury.
Hear ye, bring the jury. Let's all roll. We're going to do the things. And I saw one quick super chat. Colleen said, this is not a Dauber motion. It's a request for a Dauber motion. You don't agree that this is a genuine request. Colin's like, I don't agree that this request is genuine. I don't think the court should allow this hearing. We will see what the court decides to do, but this is not the proper use of this hearing, in my opinion. It's like my opinion. This is not what you use these hearings for. These hearings are for untrodden ground, really. If you're going to hurl a cell phone around and be like, it just turned on, is that a scientific process that you can duplicate? Maybe you have a hearing and talk about that. But if you're putting your hands in somebody's armpits to figure out time of death, maybe that's not the most sciencey of the scientific processes. The court's also going to take up other motions, including whether or not, and this was a motion that was heard a few hearings ago, whether or not the defense, not the defense, my brain is buffering, whether or not the court is going to force reporter Gretchen Voss to turn over notes and more. So with all of those considerations, we are going to go to court today, but we also have a sponsor today, and we are going to say thank you to our sponsor, and then we are going to go directly into court. So with that, the reason we bring you sponsors, A, is because then we can pay Team Baker. B, then we can rely on Law Nerds and our lovely sponsors. And C, because I like the sponsors that have stuff that helps all of us with a discount. Who doesn't love a discount? Joelle said, wait, hands in the armpits. Yeah, that happened in the Murdaugh case. And it was strange. It was strange. So today, before we zoom to Massachusetts, we're going to say thank you to our sponsor, who also is travel related. And I can understand if you're like, well, maybe we'll put it on pause. Don't worry. This will work for travel whenever you choose to travel. So a huge thank you to today's sponsor, Saily. Well, we've been talking an awful lot about cell phones lately, but one of the things we haven't talked about is making sure that you are connected when you are traveling. And so many phones today have eSIM capability that Saily makes a ton of sense. And they are today's sponsor. With Saily, you just download the app and then an eSIM can be installed onto your phone and you can put multiple plans in it. So whether you're traveling to Mexico or Europe or elsewhere, you have access to a local cellular phone network. You can preload it before you travel, pick the plan you need, and then you have up to 30 days to activate it so you can wait till you travel. Saily eSIM plans are available for iOS and Android. You can check if your device is compatible, but they also have 24/7 support and you can get a full refund if for any reason your device is not compatible. And with over 160 countries and 8 regions that are available, you're going to get some of the best rates online and you know that you're covered. So if you are ready to give Saily a try, go ahead and download the app to your phone. It is incredibly easy. And get an exclusive 15% off on Saily data plans when you use our code Emily D. Baker. That's right, just use code Emily. Well, we've been talking an awful lot about cell phones lately. Chat, that was me. That was me. I don't know what happened to the end of the code, but you've got the code. We will put on the end real quick. I don't know what happened. It just absolutely glitched, but code Emily D. Baker will get you there. Chat, I don't even know. I don't even know. Today, it's been a full day, but do not worry. We are going to go to court. I am going to see if we can figure out how to zoom to the end so you guys will see it, but code Emily D. Baker. So let me see if I can figure out how to get directly to the end. Miguelina, if you can let me know in the chat, because I don't know how to get to the last chunk of that. But if you'll let me know, that would be super, super helpful. I don't know what happened, but January is just doing the things, but we need to go to Massachusetts. So let's do that. So, okay, let's go to Massachusetts and we will grab that and then put the end of that back up in just a few minutes. So where is our court? January. Let us just go to court, shall we? Let's hope we're in time for the hear yees. And let's make sure we have our sound. As we hear the hear yees, let me know if the sound sounds good to you.
All persons have any business before the Honorable Beverly Canoni, Justice of the Norfolk Superior Court, for the County of Norfolk. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is now open.
Starting with the Commonwealth.
Good morning, Your Honor. Laura McLaughlin for the Commonwealth.
Good morning, Ms. McLaughlin.
And yes, I have noticed that all of the feeds have skipped on occasion today. It has been an ongoing issue today. So if there are little stutters, it's not you, it's the court. But we love the hear yees, don't we? I do.
Good morning, Mr. Lally.
Good morning, Your Honor. Hank Brennan for the Commonwealth.
Good morning, Mr. Brennan.
Good morning, Your Honor. Alan Jackson on behalf of Ms.
Good morning, Mr. Jackson.
Good morning, Your Honor. Robert Alessi on behalf of Ms. Reed.
Good morning, Mr. Leslie.
Hello, all of the lawyers.
David Ginetti for Karen Reed.
Good morning, Mr.
Yes,
Yannetti.
back in the
Good
small
morning, Ms.
courtroom.
Reed. Oh. Good morning, Mr. Birchie. Okay, let's see. So we've got several matters for this morning to discuss. So first, there's filed a motion to recover expert related expenses.
So the court is going to go through everything that we're going to hear today, which I appreciate. So all of you that are like, what are we covering today and how long is it going to be here? Let's go through it.
Filed a motion to recover expert related expenses from the Commonwealth, and we'll discuss that in some manner at the end of the hearing today. We've also got Mr. Birch is here on Ms. Voss's opposition to the notes. And then there's the Commonwealth's motion for reciprocal discovery pertaining to the employees of ARCCA. And the last one is the Commonwealth's motion to exclude witness Richard Green's debunked opinions. So those are in
And that's the
really
name
in
of the
that order,
motion.
except I think we should start with
That is not her saying she agrees.
that
That
I
is
received this
that is the name of the
morning.
order.
A motion to file an amicus memo.
So for all of you that are like
to be
debunked,
filed.
look, just hear me real quick. If you missed the very beginning, that's what the Commonwealth named the motion. That is the title of the motion. The court is not passing judgment or opinion on that. That is the title of the motion from the Commonwealth. She is reading off the names of each of the motions. That is what they named it. That's what they named it. So they are going to bring in the attorney for journalist Gretchen Voss to talk about whether or not she should be required to turn over her notes. So that is the first thing we're going to hear, and I'm going to put him at 1.25.
And I've read the motion and the memorandum.
I don't know where the sound just got squirrely with me. Hold on.
I'd like to start by just thanking the court for taking
The sound was fine.
opportunity to revisit the court's ruling of
Today is just going to be a whole day. Just a whole one of the days. Just,
December 5.
all right, there we go.
That
Good.
ruling allowed in full the Commonwealth's
Goodness.
reviewed motion for all audio recordings, interview notes, emails, text messages, and voicemails in the possession of Gretchen Voss or Metro Court.
There we go. Oh, some of that was
Ms.
user
Voss
error.
and Metro
Emily,
Court complied
user
with
error.
the court's order for production of documents on January 2nd by producing to the court all of the responsive materials.
This
the unredacted
is Gretchen Voss's attorney, journalist Gretchen Voss's attorney, with his opposition to the Commonwealth's request to turn over her notes and the unedited interview and statements made and the unedited recordings, et cetera, et cetera.
the tapes and the text messages that involved on-the-record communications by Voss with defendant Reed. I'm here today to implore the court to reconsider that part of its ruling, but also would require Gretchen Voss to turn over handwritten notes of an interview with Reed that the parties had agreed in advance would be off the record, indicating what it believes the notes will reveal.
She was like, it was on background.
You are unmuted.
Particular reason
No.
to
Was it really?
delve into them. So the question before the court is whether the Commonwealth should be entitled to forage through this reporter's notes and compel her to break her promise of confidentiality.
I've moved him to 1.25. He's pretty methodical in his argument, and we can zoom and catch up in real time just a little bit.
With the source in the ungrounded
that's what
hope
we're doing.
of finding relevant and material evidence somewhere in those notes that will aid in a prosecution of the defendant. The stakes for Gretchen Voss are considerable, as she set out in her second affidavit submitted to the court with our motion for reconsideration. Her effectiveness as an investigative reporter depends upon her having the ability to use the tools to reliably assure her sources that certain information they provide to the reporter will be off the record. The precedential stakes are high as well, because the Commonwealth is essentially asking the court to give no weight whatsoever to the off-the-record nature of the notes, and that is what renders a journal. Off the record is a phrase you hear in virtually every court of sentence. This is off the record, the kind of lubricant that allows a source to have a free and full exchange with the reporter.
Yes, he said lubricant.
Without having to guard every word they speak. And receiving information off the record is often a technique by a reporter to establish trust and rapport with a source. That source might be a whistleblower, might be a frightened migrant, or might, like Reed, be a criminal suspect.
So we heard the first part of this argument when we heard the first time Alessi was in court. So 2 hearings ago, I think it was. And the Commonwealth was arguing over whether or not they should have Gretchen Voss's interview and notes. So we heard the Commonwealth argue there. Gretchen Voss's attorney said, I would like to appear as a friend of the court and argue on behalf of my client who's related to this matter because they're asking about her notes, even though she's not a party in this prosecution. And we also heard on that day the argument over whether or not the Commonwealth should have access to the cell phone records for Karen Reed's father and more. The court denied a lot of those, but we are getting more argument with regard to the notes and the rest of the interview from Gretchen Voss, because there were parts of the audio that was turned over to the Commonwealth in that conversation that were redacted. And the Commonwealth's like, no, we should have access to the entirety of that interview, not redacted, and then we can argue over or whether or not we turn it over. So Casey, no, that I can't turn on the closed captions because there aren't any on this feed, and there aren't any on any of the feeds. We tried to fix that this morning and had tech issues trying to do so. So I'm sorry that you're going to have to turn them on device while we're live, but you're going to have to turn them on device while they are live, not through YouTube, but through device. I know a lot of devices will do that, but because somehow we got the rest of our lovely sponsor Saily got cut. I don't know why the rest of it didn't air. We're going to air the rest of it real quick, and I appreciate it because we have had all of the tech glitches today, and you guys are so kind and patient with them. And then we'll get back into the rest of his argument. So, for the rest of our lovely spot with our sponsor Saily, who provides eSIMs, whether you are traveling or just need a second SIM card, we have a great discount for you. And let's get to that discount right now. So if you are ready to give Saily a try, go ahead and download the app to your phone. It is incredibly easy, and get an exclusive 15% off on Saily data plans when you use our code Emily D. Baker. That's right, just use code Emily D. Baker at checkout to get an exclusive 15% discount on Saily eSIM plans. Let's get back to today's stream. And if you missed any of it, it is pinned in the comments as well. It will be pinned in the bottom, and it is pinned at the top. So with that, let us get back to court. Huge thank you to our sponsor, Saily, so that T. Baker can bring you all of the things all of the time. All right, let's go.
On page 2 of our motion for reconsideration, we quote from Primer on Journalism that says, off-the-record interviews, quote, are essential in building trust between journalists and their sources, allowing for candid discussions that can provide context or background without the risk of public disclosure.
I mean,
The result, it says, is to enhance
unless you have to go to
the depth of
court.
the reporting and provide leads for other sources. In Ms. Voss's case, she states in her second affidavit, which we filed with motion for reconsideration, at paragraph 11, she says, obtaining information from sources off the record is a normal and critical part of my work. Like most investigative reporters, I frequently agree with sources, including keeping my word on this is critical to maintaining credibility and trust, and thus maintain source relationships while not interfering with the flow of important information to the public. The court's December 5 order forces Gretchen Voss to choose between either keeping the word to her source and thereby violating the court's command, or else
That's an
obeying the court's
important
order
note.
and establishing herself as a reporter whose word cannot be trusted.
There's a third option. So the court on December 5th ordered that Gretchen Voss had to turn everything over. Does that mean it's going to come in at the second trial? Not necessarily. There are still then all the arguments about whether or not it's proper evidence, etc. So it just really depends on whether it can come in, but the court ordered it disclosed to the Commonwealth. What he said is this either forces the reporter to turn over her notes or disobey a court order. And I mean, that's really the option. We have seen reporters in the past that are like, fine, hold me in contempt. Hold me in contempt. I'm not turning it over. So it puts the reporter in a position where she has to do one or the other. And he is not thrilled about it. Also, I do have this at 1.25. So it is a little bit zoomed, which exaggerates everything. So just keep that in mind. But the argument here is, well, then she has to betray the trust of those who sat down with her. However, if you have a pending criminal case and choose to give interviews, then I don't think there's a reasonable expectation that that interview will not be obtained by law enforcement. You have the right to remain silent, but many do not have the capability. This is one of those moments where you don't have to talk. But when you choose to, they're going to try to get to it.
It's an unnecessary choice to present to her, at least on the facts of this case. The court shouldn't insist on publication of the off-the-record notes because the Commonwealth has failed to meet its burden under Rule 17 to show that mandated production of the records on the facts of this case would not be unreasonable or oppressive. And also because requiring Voss to turn over these confidential notes would damage First Amendment interests more than it would benefit the public in achieving justice for this criminal defendant. And I keep saying on these facts, because it's very clear that the inquiry is a fact-sensitive one. The First Circuit
He's going through
ruled
the standard.
that under Massachusetts law, the task is one that demands sensitivity, invites flexibility, and defies formula. While obviously the discretion of the trial judge has wide scope, it is a discretion informed by an awareness of First Amendment values and the precedential effect which decision in any one case would be likely to have. And in Re Cusimano in 1998, the First Circuit said, that was a case like this one, where that involved a demand for confidential information from an identified source. The same court reinforced the fact-specific nature of the inquiry.
And he's going
In Cusimano,
through
they
a
said
lot
when
of what he
subpoena
filed. It
seeks
looks like
divulgement of confidential information compiled by a journalist in anticipation of publication. Courts must apply a balancing test. This test contemplates consideration of a myriad of factors, often uniquely drawn out of the factual circumstances of the particular case. Now, as I noted in the December 5 order, the court drew no distinction between the on-the-record and off-the-record interviews when it applied the Massachusetts balancing test for mandating production of reporters' notes, texts, and audio texts, audio recordings. It did not treat this confidentiality promise as a factor in the equation. That we submitted was critical oversight. Because whether you call it a privilege,
I don't know if a confidentiality promise is going to count in Massachusetts.
That there is some degree of deference
Some
given to a promise of
shield.
confidentiality. And Bruno and Stillman,
And that's what he's arguing.
Courts faced with enforcing requests for the discovery of materials. No, it says materials, not.
For all of those asking, not everything is protected all the time without evaluation. He's going through the balancing test that the court has to balance. One of the things that balances against Karen Reed is that her lawyers were there too. So those conversations are balancing. So he is arguing with the court to balance that test.
Source identities. And courts faced with enforcing requests for the discovery of materials used in the preparation of journalistic reports should be aware of the possibility that the unlimited or unthinking allowance of such requests would impinge upon First Amendment rights. In determining what, if any, limits should accordingly be placed.
Well, there's the
upon
what, if
granting
any.
of such
I think
requests,
that's an appropriate
courts
use of what,
must
if any,
balance
though.
the potential harm to the free flow of information.
That was the
might
right what, if
result
any.
Against the asserted need for the requested information. So, what are the factors that the court should look at when conducting an analysis under Rule 17 and under the balancing test? Taking Rule 17 first, set out in the LaRouche case, they cite the Nixon case, where the Supreme Court ruled that in order to require production prior to trial, the moving party has to show, number one, that the documents are evidentiary and relevant, number two, that they're not otherwise procurable reasonably in advance of trial by the exercise of due diligence, number three, that the party cannot properly prepare for trial without such production and inspection in advance of trial, and that the failure to obtain such inspection may tend unreasonably to delay the trial. And number four, that the application is made in good faith and
So those are the
is
arguments
not intended as a general fishing
for the
expedition.
balancing here.
In short, the court was explaining that the special prosecutor in Nixon was required to clear three hurdles: relevancy, admissibility, and specificity. And the court held in Nixon that there was a sufficient likelihood that the tapes contained conversations relevant to the offenses charged.
When do
and
you turn it
sufficient
over?
preliminary showing
The
that the
argument is
subpoenaed
for
tapes
when do you turn
contained
it over?
admissible evidence. In this case, however, there's been no showing that the handwritten notes contain admissible evidence.
And yes, the feed is a little choppy. It does do
When you
that.
apply it to the facts of this case, there is uncertain relevancy of the information in the off-the-record notes. Not seeing them, it's hard to know whether they're relevant or not. But there's no specificity whatsoever in the form of
Right.
preliminary show.
Right. You can't argue that the Commonwealth can say how it's relevant if it's all redacted and they can't see it. Like, I get it. It's like, well, relevancy. They can't argue relevancy if they don't know what it is.
Commonwealth that the notes contained admissible
I get it.
evidence. Compare that to the materials the court ordered disclosed. The court found that there were indications in the redacted audio tapes and admissible evidence. That's on page 5 of the court's order, which says the Rule 17 standard is satisfied, not only based on its age. But there's no examination whatsoever of whether the interview notes would be anything more than a fishing expedition. To the contrary, the fact that nothing from that interview that resulted in the handwritten notes, nothing from that interview was used in the story. And that would suggest that the interview did not contain significant relevant information. As to the balancing test in the First Amendment interests, here too.
Or it contained really relevant information that they didn't want to put into the public eye before trial.
Confidential information has extra protection because, as stated in LaRouche, disclosure of such confidential material would clearly jeopardize the ability of journalists and the media to gather information and therefore would have a chilling effect on speech. The court in LaRouche identified First Amendment interests that militate against disclosure of confidential information. One was the threat of judicial intrusion into the news-gathering process. Another was the disadvantage of a journalist appearing to be a research tool for the government. Number 3 was the resulting disincentive to keep outtakes, or in our case, keep notes. And number 4, the burden on journalists' time and records and resources in responding to subpoena of Chris Vogel that was submitted with our original opposition.
So they are really asking the court to reconsider.
In his affidavit from paragraphs 13 through 18. He says he worries that compelled disclosure may lead to a public perception that Mrs. Voss is taking sides in this case or is acting as an investigative arm for the judiciary. Trust in the news media is already fragile because reporters compile.
Emily, don't say you don't know if the internet would do that, because the internet's going to internet. But I don't know if the court forced Gretchen Voss to turn over notes that she took for an interview that she was doing for a story, if people are going to suddenly think that Gretchen Voss wants to assist the Commonwealth in the prosecution of this case. I understand the concern, but I think it's a leap. The court forcing you to turn it over is different, but I also can understand that it seems that this reporter is nervous about the internet being like, well, then you should take the fine or go to jail or be in contempt or whatever. So I think there is concern there that the forced turnover will have negative repercussions beyond just turning it over.
Information for a living. They will always be attractive targets of discovery for one side or the other.
And you don't want to open that door that the media is always compelled to turn things over. I get it.
Reinforce the impression that objective journalists are working as agents of the government or the defense. The Fourth Estate can only serve its role as a pillar of democracy if it has the public's trust. Second concern.
And free press is a guaranteed right.
Pointed out is that in his affidavit.
Wait, sir, have you argued the Constitution yet? Because if a branch of government is forcing the turnover of notes, then is that really a free press if a different branch of government can force the press to disclose things? Like, where is the boundary there? And those are conversations that are going to keep happening.
Risk of compelled disclosure is that if it becomes easy or routine to subpoena journalists to hand over their interview
I don't know
notes,
if it's easy.
The legal and administrative costs of battling or complying will chip away at the precarious resources of much of the media.
It'll chip away at independent media, that's for sure.
What's concerning him was that easy allowance of media subpoenas also risks leading to a decline in investigative journalism altogether. This is the most expensive kind of journalism. Reporting, writing, editing, and fact-checking investigative pieces take significant time and resources. Magazines like Boston Magazine will not be able to risk becoming enmeshed in situations such as this one, with the result that they shy away from controversial topics and the flow of vigorous reporting will suffer. We'll feel we have no choice but to select tamer, less controversial topics for our coverage. Another concern expressed by Editor Vogel is that reporters will be incentivized to destroy notes and interview tapes after a story is published. And that could harm the news outlet, especially in the way they gather information, in the way they can interview notes, aware as they will be that their work may become the subject of public and judicial oversight. And finally, one factor that separates this case from many other cases out there is that Gretchen Voss has been the subject of invasive vitriol simply for writing about this controversial and very public matter. Public disclosure of their interview notes in this case risks putting her again in the limelight and triggering a new round of harassment. Now, the court mentioned in its ruling that it appeared that she's no longer in fear of harassment because she had attended every day of the trial. I would submit that shows that she was dedicated to covering the trial, come what may. She tells me she has, in the recent past, gotten more pushback on social media, including the fact that one commenter on Facebook, who I won't name, posted her personal telephone number.
Yeah, getting doxxed is the worst.
To that post suggested I'll call her right away. And she's received several strange phone calls since then.
I can understand posting somebody's office number. Hey, if you don't like what Boston Magazine's publishing, call up Boston Magazine and be like, hey, Boston Magazine, guess what I'm not going to do? I'm not going to subscribe to you. I'm not going to pay you. I don't like what you're reporting on. Don't report on it. And they're going to be like, well, we report on what we report on, pay or don't pay. Do not dox people at their homes. Like, what are you doing? It's not y'all, law nerds. I'm yelling with you, not at you. We're yelling together. Look, what? Just call the editor. Call the editor. Write a strongly worded letter to the editor. Doxing people to try to silence them is cowardly bullshit, and it has no place. If you disagree with someone, tell them you disagree. Call their editor. Don't subscribe to their magazine. Don't give them the clicks and views. But there are still boundaries. And it's just, don't go real world with people.
Because of the
And I don't doubt
the
that.
First Amendment and Article 16 interests.
Based on the vitriol some of these cases bring forth, I don't doubt that.
We ask this court to consider its December 5 ruling and deny that part of the Commonwealth's motion that seeks those notes.
Chat, your point's well taken. She's the only one that didn't
Thank you very much.
It seems that the reporter is the only one that didn't rehome her shit, and everyone else did. But harassing people to silence them is absolute bullshit. Don't go real world with people. There are realms and room to disagree without doxing. All right.
I do have
We're going to slow this back down to normal speed while the court asks questions.
one point to make to you, Mr. Burt.
And this was from the December 5th ruling.
Amicus brief, or the memo that was filed this morning.
This morning. It was filed this morning. Don't do that either.
I just want to be clear that I am not looking for Ms. Voss's own interpretations as well as her likely impressions and thoughts about the interview and overall story to be provided. But it makes sense to me, and I'm going to hear from the Commonwealth, and if you want to respond first, that any information that reflects or relates to conversations with the defendant must be turned over.
Well, that's where that is.
I'm not sure what the question is.
So I'm not looking, the amicus brief and your arguments suggest that if I order these notes to be provided, and just to be clear, I do appreciate that they were provided to me to review in camera. So I can see a distinction between what I'm being told that generally all notes reflect the author's interpretations as well as her likely impressions and thoughts about the interview and overall story. That's not what I'm considering releasing. But I think in this criminal case, the Commonwealth has proven that any material that reflects or relates to communication with the defendant must be turned over. So what I'm going to propose is that I do believe that there's some material in these notes that I don't need to provide to the Commonwealth, that I don't need to order be provided to the Commonwealth, that are just sort of observations. It's the communication between the I have the notes.
So the court reviewed these in camera and had all the notes and reviewed them in camera and said, look, I've reviewed these notes in camera. Any conversations with defendants, the things that Karen Reed said, those are things that are getting turned over. But impressions on the story, other information on the story, thoughts, kind of more work product type things don't need to be turned over. But reflections of what the defendant said, that needs to be turned over to the Commonwealth. And so the court had said that previously and is now parsing through what goes over with the notes and what doesn't get turned over with the notes.
Can propose redactions to things that are not reflective of communication with the defendant, observations, things of that nature.
Well, Your Honor, there's nothing in the interview notes that is reflected in
The
the
court
story
disagrees.
except architectural details, that there's a rosary on the bureau or the wall is blue or whatever it might be. And I went through the notes with this question in mind. Can you separate the impressions, integrity of the thoughts of the writer from the statements of the interviewee? And I don't think they're distinguishable. I think they're
Okay.
all melded together in one.
Well, the court disagrees. It sounds
Frankly,
like.
it's her selection of questions that she asks Ms. Reed that gives an eye hole into
An eye hole?
what her thoughts are about the case.
Okay, counsel.
She shouldn't have to produce that work product. And the Commonwealth hasn't shown that there's any more relevancy to these conversations with Gretchen Voss than there would be with any other conversation that Ms. Reed had with anyone else.
Well, they're trying to get to all of them.
There's no reason for the Commonwealth to be going after.
Well, the Commonwealth's going after Gretchen Voss because she works for Boston Magazine and is in Boston. They've also tried to go after ABC. ABC's not in the same state, so that makes it a little bit more difficult.
Gretchen Voss as a reporter for this.
They went
other
after
than the
everybody.
fact That she's a reporter and she's done the investigative work already that presumably the Commonwealth has already done.
Okay,
Thank you.
thank you. Commonwealth?
Your Honor, I'll simply say we defer to the court.
Thank you.
I hate how choppy. And that is not you, that is just
All
the
right,
feed.
So
The Commonwealth has
paper
deferred to the court,
442.
and we are moving on to the next motion.
This is the Commonwealth's motion for reciprocal discovery pertaining.
We're moving on to the ARCCA experts. Now, hear me for a moment. Tune back in. If you're like, wait, what's happening with the Commonwealth of Massachusetts? The judge already ruled on what needed to be turned over. The attorney for Gretchen Voss came in and was like, can you please not? And the judge seems to be inclined to say these are going to be redacted in part, but not kept out from discovery entirely. Now we're getting into the ARCCA experts. If you remember, these are the experts that we have fondly called in the chat the crash daddies. They are biomechanical and biomedical engineers. They testified in the first trial. They were not hired by Karen Reed's defense team. They were not hired by the Commonwealth. They were hired as part of the federal investigation by, I mean, technically probably by the U.S. attorneys, but we don't have a sassy soundbite for the U.S. attorney's office. So the FBI is who it is. The Commonwealth has asked that there be more discovery with regard to the ARCCA experts, or if there can't be more discovery, that those experts perhaps be excluded for discovery violations. Do I think they're going to be excluded? No. Am I interested to see what they continue to argue with regard to the discovery that they are seeking? I'm interested to hear what they have to say, but this is not saying that the experts aren't experts. I've seen a lot of misunderstanding of this request. The Commonwealth is arguing that the discovery hasn't been turned over. There won't be adequate discovery. And when there's not adequate discovery, then it's a discovery issue, not a they're not experts issue. So this is with regard to discovery. And I think we will see Hank Brennan getting up to argue this right now.
To employees of ARCCA. And I know from when we were last in court, the Commonwealth was perhaps having conversations with the federal people.
The federal
to
people.
See if you could get anywhere with this. Is there anything I need to know in that regard? And if we need to do it at sidebar, we can do it at sidebar.
No!
I don't think there's a need, Your Honor.
Okay.
Thanks,
Although
Brennan.
it's not incumbent on the Commonwealth to pursue Rule 14 discovery of a party that's going to proffer an expert, Commonwealth made best efforts anyways. I filed a TUI letter, and I was unexpectedly not disappointed when I received a response last night. It's insufficient, it's inadequate, so the issue of pursuing Rule 14 discovery, for the proponent of the expert, that being the defense in this case, is something that is a matter we're going to have to address.
Okay.
I did speak to the defense this morning. Since the TUI letter came last night, they have, I don't want to speak for them, but have asked if we would consider some time so they can respond. I am content if it gets deferred until the next date, but it is an argument that needs to be made.
Okay, who's arguing now for the defendant?
Good morning, Your Honor.
Morning.
I agree with Mr. Brennan's recitation of our conversation this morning. If it pleases the court.
He's like, sure, we need to have this conversation, just not right now.
Late last night, reviewed it last night. I think that it'll be incumbent for me to at least analyze that letter in a little bit more detail and utilize that letter in my response to the Rule 14 argument. So if we can have another date.
Sure. Well, we have next week, Thursday and Friday scheduled.
That's what I was thinking.
So we'll do this next week and come up with proposals on how we can certainly not violate anything that the federal court has said we can't do, but ways that we can go about it.
We'll be mindful.
All right, so if you can work on that, I'd appreciate that. Sure. So I will take the lead from the two of you on that.
Thank you.
Okay. All right, so this brings us to the
Look at them moving right
Commonwealth's
along.
motion.
As we switch motions, because they are going to take that up next week. As we switch motions, a number of you are asking in the chat, federal court, what do you mean? There is a federal investigation and there has been a federal grand jury going on with regard to this case. And there is boundaries on what discovery, because of the secret nature of a grand jury, can be turned over. So there are boundaries between what might be discovered by these attorneys or made public in this case and what's going on in the federal grand jury. It is, I can't properly articulate how unusual it is that there is a federal grand jury proceeding while there is a state level prosecution proceeding regarding the same case. And that is odd. Double Helix asked, who is the defendant in the federal case? From everything that has been made public, it seems that it is an investigative grand jury and that there is not a quote unquote defendant. There may be a target, but it seems that they are investigating the investigation. That seems to be what they are doing. But there is stuff that will not be made public because of that. And they are arguing over the discovery with regard to that. And now we're moving on to the next hearing in line.
To exclude defense witness Richard Green's debunked opinions.
That's the name of the motion. That's not passing
So I have
judgment.
received,
I know y'all don't like this, Judge, but
great
that's not
deal
her
of
words.
pleadings on this. So the Commonwealth's motion, and there was a affidavit attached, a report attached from Mr. Whiffen. The defense has filed an opposition, an affidavit from Mr. Green, and then another affidavit from Mr. Green that doesn't, they're two separate affidavits. And the affidavits are clearly different in substance, so I'm
Yes.
a little, I don't know what you want me to think about that, but why don't we hear the Commonwealth on its motion first?
And I'm holding on to a lot of your questions about the federal grand jury to get when we get past this. I want to hear the Commonwealth's argument on this.
May it please the court, we filed a motion to exclude Mr. Green as a witness regarding 2 points. The first is a claim that a witness's phone made a search for a phrase to the effect of how long to die in the cold at 2:27 a.m. And secondly, to exclude an opinion that there was some type of intentional deletion of that entry. In this case, I propose, on behalf of the Commonwealth, is appropriate for a Lanigan hearing. At that Lanigan hearing, I suggest that Mr. Green should testify and answer questions about his affidavit and his opinions that he would like to subject the jury to. In fairness, the government would call an expert as well. This case, as the court proposed, potentially scheduled for next week. Mr. Whiffen would not be available, but Ms. Hyde would be available, and I would call her as a witness. Mr. Whiffen, if necessary, is available later in the month as a witness. My suggestion is there should be 2 witnesses, Mr. Green and 1 witness from the Commonwealth. The Commonwealth witness will be able to explain the science, the data, forensic science,
This
and
is a difference of
methodology.
opinion.
And Mr. Green, I suspect, should be in a position to explain his ultimate opinions because what we see in his affidavit is an absence of methodology. Mr. Green has filed 2 affidavits in this case. They are very similar, but there are very significant changes to those affidavits. And it stands out as very interesting, the changes to the affidavits, when I look at them. On number 3, he changes his characterization of what his profession is. He originally calls himself a forensic technician, and then the updated affidavit cites that he's a computer network technician. Now that is odd because usually a professional getting the simple explanation of what he does stands out. Also stands out when using technical terms. They either were wrong or changed from the first affidavit to the second affidavit. For example, number 9. He talks about the download as a full file system extraction, then changed to an Apple iOS full file system. My point is that when you look, this isn't simply misspellings or poor grammar. There are terms of art that are wrong between the affidavits or changed. When you're using the terminology of an item that is a forensic tool, such as gray key, it is spelled wrong throughout the affidavit. And so it seems to me,
Sir,
that Mr. Green's affidavit had some assistance in building it. And the tone of the affidavit
oh dear.
supports that thought. When we look at Mr. Green's affidavit, it is
He thinks the
not that of a
attorneys wrote
forensic
it.
examiner, it's that of an advocate for the defense.
There
When we
are
look
parts
at
of
his
it.
affidavit, there is quite a bit of advocacy and insinuation.
There are parts of the affidavit that are argument. There are parts of the affidavit that do make specific pointed arguments. So Brennan's like, I think that this is defense counsel. Yeah, okay.
And surmise and conjecture and claims that have no factual basis, but there is little on methodology. In ways, it is a very dangerous affidavit to simply make assaultive comments that a user did something, purposely deleted a very important phrase, how long to die in the cold, without any forensic data or evaluation or validation. Suggesting, but never proving, never providing fact, that there was some type of manipulation or tampering with evidence. Now, this is not the role of a forensic examiner unless there is proof, in fact, that happened. But when we look through his entire affidavit, we don't see any attachment of raw data, or we don't see an updated report. We don't see any viable information
Oh, this is going to
that
get feisty
in any
today.
way supports his speculative accusations. And so the defense, without having an opportunity for Mr. Green prior to trial, stand behind these statements under oath, would like him simply to come before the jury, make these salacious comments, and then leave it to the government to knock it down. And that might be a common approach, reviewing the transcripts of this case, but the Commonwealth does not intend to simply let evidence come in that's not qualified,
I've
that's
got to
not
put this hair
factually
up.
sound, and then go knock down glass houses. That is not the approach the government is going to take to this case.
I'm not leaving. I just need to put my
Mr.
hair
Green is
up.
going to testify. He should have a report that is factually based with methodology supporting these claims, these narratives that he's proposing.
Oh, boy.
Considering testing in this case, there are certain tools that are used. The defense wants to propose that there's some type of race that Mr. Green looked at or used more tools than a Commonwealth expert. The tool is simply software. A good analogy is that of an X-ray. Anybody can take an X-ray, but it takes an expert then to interpret the X-ray, to interpret the data. In this case, Mr. Green, in his affidavit, proposes that because he used a number of tools, because he has a number of X-rays, that somehow there's significance to it. But what it lacks is a forensic analysis of that information. He cites two opinions.
All right.
His first opinion is based
Sorry,
on
we're
Fulbright processing
doing our best
and
today.
Axiom processing. I'm
couldn't-
not going to go through all the
I couldn't handle
details
it
of the
anymore.
dispute or go through a technical assault on each point, although that may come at some point. But the overall idea of this evidence
He's like,
is
we might
why
make more
this should be
motions.
subject to a Lanigan hearing, and why we are willing to call our own expert as well, so that the record is clear and the science and data is clear. Instead of doing validation or testing, relying on Cellbrite, what Mr. Green has done in section number 13 of his affidavit is step aside from methodology, and instead he cites that he called Cellbrite technical service. Now, this is the forensic examiner who is supposed to go through the process, and yet he defers it to technical support of Cellbrite. Technical support in Cellbrite he relies on to say that this artifact where this search is stored is appropriate. And he remains standing on that foundation as why somehow there's some validation that this search occurred at 227. But then when he learns that Cellbrite, after actually doing analysis and study and updates and engage in methodology and review, determined that the way that was assessed is unreliable and the program has been updated, which no longer shows the 227 search at 227, and I'll explain why for good reason, and I'm sure the court has heard this before.
We heard it at trial.
Mr. Green then denounces the very source that he relies on. And so on one hand, he's saying, I relied on technical assistance of Cellbrite, but then when they told me what I didn't like, I can ignore that part.
That's what a battle of the experts is for.
He then defers to Axiom.
That's why there's
Axiom,
multiple tools.
The government, the defense touts
My
is
chair and my desk are
a
fighting.
separate source that reinforces the same point when clearly it doesn't. You
Sorry,
can see
y'all.
in number 14 of Mr. Green's affidavit, he talks about the fact he uses these different programs because he wants to view data. And that gets back to the X-ray analogy. He is viewing data from many different programs that say the same thing, but he never. What is troublesome about his affidavit
The
in section
skips
14
are from the
is
feed,
the
y'all.
attempt
It's
to
not
use
you.
resource material
At least they're little,
to
but
convince
still.
this court that rather than methodology, these summary statements are something that the court should rely on. And so what he does is he takes an excerpt, page 7 of his affidavit.
This is
number
what
14,
cross-examination is for, though.
and he says that he reviews the Axiom user manual describing the artifact as follows: that the artifact is in Safari suspended state tabs, and then has a last interaction date time, and the date and time of the current tab state when it was last interacted with on the local device. And so he's taking a piece of the manual, they don't introduce the manual, and he tries to use that to buttress that this search happened at 227.
And then you bring in a different expert and they
Which
say a
not
different thing and
offered.
the jury decides.
Is that in the Axiom notes,
You don't get to decide what
in
the
their artifact
expert
reference
says.
guide for the description of Safari suspended state tabs, which he's referring to. And this is the death knell, really, for the analogy that the defense tries to make.
He did not say death note. He said death nail. I know, accent. Massachusetts accent. But Brennan, don't suggest the death note to anybody.
The Safari suspended tabs
not gonna work.
contains the current state of each browser tab in Safari that is currently open on the local device. The date and time are only updated when the user interacts with that tab on the local device. Since these are local tab states, results from the
He might have said
artifact
death knell.
may
He might have.
contain an earlier date and time compared to the results in the Safari history artifact if iCloud Safari synchronization is enabled across multiple devices on one iCloud account.
Still not Death Note.
And so, by axiom itself, it makes clear that an artifact in a tab can reflect a time that is much earlier than the actual search. And this has been presented to the court, and we've provided the trial transcripts of Ms. Hyde and Mr. Whiffen. When a tab is open, many tabs can be open, it is open at a particular time. And if that tab is reused, the original time will imprint.
And that's what
And so-
your experts are for.
Certain of the opinions by makes mention of them in his report, and yet he does nothing as far as validation to consider the arguments and dispel them. He does nothing in his affidavit to address the methodology. Quite to the contrary, when you see Mr. Whiffen and Ms. Hyde's reports, it isn't baseless opinions and advocacy of a side. When you look at their reports, it is replete with methodology, fact-based, information-based, the study of the particular device at hand. The contrast between the actual use of methodology that is reflected in Ms. Hyde and Mr. Whiffen's report and this affidavit is so clear. Now, there are two opinions that are proposed pursuant to this affidavit. The first is the claim that How Long to Die in the Cold was somehow inputted at 2:27. The only effort that appears in this affidavit by Mr. Green is in section 15, where he did a low-level analysis of the wall file. Now, I am not an expert, and that's why the court should hear from Ms. Hyde or Mr. Whiffen and Mr. Green. But a simple understanding of the data science is that the wall file can contain information as a repository. And the description or misunderstanding by Mr. Green of the wall file is clear in his affidavit. In fact,
That's what your
he
expert's
implies
for.
that there were 3 searches in his affidavit, number 16, when almost everybody universally agrees who's looked at this phone that there were 2. And so there's no surprise that his second opinion is an attempt really just to create confusion, to disparage, and to make claims that are factually untrue. It's necessary to have this claim because number one doesn't have any resonance. There's no methodology to support number one. So of course the fallback is somebody did something somewhere somehow. Not an uncommon refrain that we hear. And so what the claim or the opinion number 2 the defense would like the jury to hear is that somebody somehow, whether it was a person, presumably the witness in this case, or the police somehow manipulated the phone. I dare say there's no evidence to support that. And yet, in an affidavit under oath to the court, in an attempt of advocacy, this witness is comfortable and willing to promote a claim that has no factual basis. If a witness, an expert, is going to promote in an affidavit a claim with no factual basis, we should not trust, without vetting that witness, that their other claims have any merit or value. In opinion number 2, this expert, so-called expert, takes the liberty to say that the McCabe cell phone could have been manipulated. Not that it was, not that I did a study, not that I have a fact. It could have been manipulated, then rehashed after manipulation with an extraordinary conspiracy in the world of forensic science to be able to accomplish all of those tasks. So if he has no basis in fact or methodology, no good faith basis to make this assertion, why is he? Why is he? It is because the claims he makes in opinion number 1 are so scientifically and forensically unsound. This is a tactic to confuse the issue. And think about the import of this baseless claim by Mr. Green. It is suggesting that a witness with no other evidence whatsoever, was involved in a conspiracy to murder somebody. That's the implication that he wants the jury to
I mean,
be
I think that's
confused
the
by. Otherwise,
implication the
there'd be no
defense
other
made.
reason to make the suggestion. That is an extraordinarily harsh claim when you don't have any facts to back it up. Now, how could one cause manipulation? There is scientific ways that could be explained how manipulation could occur, but we don't see any of that in this affidavit because it didn't exist in this case, because there was no deletion or manipulation by the witness. There was no manipulation by the police who processed this phone. If there was, there would be some proof. This affidavit speaks volumes by the absence of fact in data and science. Mr. Green does nothing to try to demonstrate that there was user deletion on this phone or that there was manipulation by the police.
He did say could. I will give you
When
he
you
said
look at
could
the data in the phone,
in his affidavit.
the question arises, why is there a 624 search and not a 623 search? The phone stores the last entry into the tab. It's not just science, it's common sense. Common sense that Mr. Green ignores. And so not being able to prove user manipulation because it didn't happen, he turns to police manipulation. And he says that he complains that he did not receive the PDF when he received the download. And because there was a production at different times, he then sprints out into a different universe and suggests that somehow it must be because there's manipulation. And again, doesn't prove it. There's actually ways that a real forensic examiner can look at the PDF, the gray key file, and the phone and determine whether manipulation occurred. There's a program called XMP and another one called Magic. The Commonwealth's
It's called
witnesses
Magic.
went through that process. No manipulation.
The court. How
But
did you
Mr.
discover this?
Green doesn't even go
Witness.
through the process
Magic.
to disprove his own theories. If he used methodology, he could simply dispel his own claims. It's either he doesn't understand the forensic technology to do that, or he chooses not to do it so he can just posit hand grenades throughout the case and let them resonate wherever they fall. In an attempt to create some
He's using
doubt or
all the words
uncertainty
today.
or merit some conspiracy, he lists a number of what he calls anomalies, which are really not anomalies at all. I could go through each one of them.
Well,
I could
No.
give a difference of opinion. I could show
a difference
that
of
Mr.
opinion is what a
Green's
jury's here for.
anomalies have no basis in fact, but suffice to say, I think this should be done by qualified experts, and that's why there should be a Lanigan hearing. There is such misunderstanding of forensic science in Mr. Green's claims and anomalies. If he's going to make these assertions before it goes before a jury, he should sit in the witness seat under oath, as the Commonwealth witnesses should as well, and he should justify, explain to the court why he did not engage in methodology and how he has come to these extraordinarily baseless, inaccurate, and prejudicial claims. The Commonwealth has to, the court rather, has to look at Lanigan and whether or not a hearing is appropriate in
Warranted?
this case. When we look at the different non-binding factors of Lanigan, we look at number one, whether
Well, we're not
it has
there
been
yet.
generally accepted in the scientific community. This software has been generally accepted in the scientific community. So hasn't the effort of a forensic examiner, the expertise. And the defense complains in their motion, the Commonwealth has not properly addressed the methodology of Mr. Green. Well, the reason why is Mr. Green does not provide any methodology. So this is the way to address the methodology. Number two, the opinions have been or can be subjected to testing. Well,
We know the factors.
We see Ms. Hyde and Mr. Whiffin's report directly contradict the assertions, the unsupported assertions of Mr. Green. There is no testing that his opinions have been subjected to. There is no view.
He does the exact same
There's
thing
no
your
other
experts do.
alternative support for his opinions. They're just broad, baseless claims. Number 3, has been subjected to peer review and publication. Certainly the science, the forensic science has, the software has.
How is it
but
different?
The interpretation and Mr. Green's interpretations, it hasn't been subjected to anything. In fact, it changes. Has an unacceptably high known or potential rate of error. Well, if we see and read Ms. Hyde and Mr. Whitman's report, it's not just a high level of error, it's gross error, it's total error. It's wrong. And is governed by recognized standards. Well, if you look at the history report that the defense filed as an attachment, it talks about a forensic examiner's obligations to verify, to test things that Mr. Green didn't do. Their own report that they offer in support undermines the idea that Mr. Green did anything to validate or support his opinion. And as we see from both Selbright, he does not follow the protocol. He does not follow Axiom or the guidance that they give him. He sidesteps both of them to give the opinion he wants to advocate for the defense. At every turn, the positions of Mr. Green are not only unsupported, they're unverified. And so what arises from this subterfuge is that Mr. Green is really just a vessel, or an attempted vessel, for the defense, third-party public defense. It is not lost on me, I'm not unmindful of the data on the phone being a search, How Long Die in the Cold, that occurred after 6 a.m. in that morning coincides with first responders' testimony that the defendant herself was asking these very same questions around that time about Mr. O'Keefe and how long he
I mean,
was
that's for
alive and cold.
argument.
Under the extraordinary broadness of circumstances. and
That's
the
why there's multiple
depth
experts, sir. That's how
the
that
amount
works
of
with
witnesses
2
and
experts.
information in this case, it is hard to think that that just happened by happenstance. That there is a inquiry, something forming in the mind of the accused, is then shared with the witness, Ms. McCabe, and in response, she makes the search, which is, he has no methodology, and he's wrong on the science. In addition to the fact that he wants to now appear as advocate for the defense.
The
and
feed
accuse
is jumping,
everybody
that
and
wasn't
anybody
you.
without articulating who, just anybody other than the defense. He should have to stand behind those claims under oath. And so I'm asking for a Landigan hearing. We are not shying from our burden. We're more than happy to bring in a witness so the court can contrast the two. Thank you.
All right, thank you. Mr. Alessi?
Okay. All right, Mr. Alessi. Mr. Alessi's going to be pissed. I imagine Mr. Alessi's going to be real pissed. You guys, let me try. Hold on. Since we're getting to Mr. Alessi, there's one pool camera. So if this feed is jumping, then all the feeds derived therefrom will be too, because there is literally one feed. But let me try one. Let's give us 1 second and see. Because, well, give me 1 second and see if we can grab a different feed that doesn't have crap all over the bottom of it, which is really the thing I hate the most. So let's see if we can get back in time to where Mr. Alessi is and see if a different feed has a little bit of a smoother transmission from the courtroom. And let's see. I think, well, we're going to have to let it roll and see, but hopefully the sound is just as good, and we will give it a moment because there isn't a ton of stuff down below. Let me just get to where Mr. Alessi's joining us. Let me switch feeds real quick and see. We tried again to sort all this morning, and it just was not. It was not playing kindly with us. We had all of the tech fights this morning. So let's give their feed a try and see how this goes. I hate the way they title their feed, though. I try not to be ragey about things, but today, all the things. But let's see if it has less buffers. Oh, the video quality is way worse, though. Oh, the video quality is way worse. Yeah, I don't love that.
May it please the court,
All right, let's see.
Mr. Green
Oh, nope.
is eminent.
And the sound is nope. Can't with that. Can't with the sound. Cannot, y'all. Cannot. Absolutely just killing me there. What? Nope. Wrong one. Sorry, y'all. We're gonna switch back. I cannot. The sound was just like not even a moment of a fucking chance. That was not good at all. All right. We're gonna flip it and reverse it. And back to where we are. Yep. Nope. That was not happening. All right. We tried.
May it please the court, Mr. Green is eminently qualified to provide testimony in this case with regard to the subject matter that has been challenged by the prosecution.
It was not helpful.
In this case, and that is with regards to the search of House Long to die in the cold that occurred at 2:27:40 a.m. on January 29th, 2022. Mr. Green, and I want to cover the baseline for this hearing first. Mr. Green testified at the first trial. He testified without objections as to his qualifications. He testified without objections to his methodology. Any limiting or curative instructions with regard to either his qualifications or methodology.
Oh, unless he's
nor did the
pissed.
prosecution, after his testimony, stand up and ask for any such limitations or qualification. The baseline for his qualifications and methodology was established, again, without objection. And
That's not your phone. That's happening at court. Did you see the bailiff immediately be like, what is happening? At least it's a kind of normal alarm and not a custom ringtone.
But they are being challenged now.
I was just waiting, Your Honor. They are being challenged now, but the reason I state that is because what Mr. Green has provided in response to this motion is even more detail than what happened in the first trial. In Mr.
So the feed just ended? Should have just stuck with the other one, Emily. Today is going swimmingly, chat. God, if you've ever had a day that's just all of a day, welcome. Welcome to that day. What? What is happening today? All right, give me a minute, chat. We'll just go back to the other one. The sound as good? No, but at least it didn't end. Jesus. Streaming is dynamic. Streaming is dynamic. January, day 735. You've been a delight. Thank you. Thank you. I know we can't even blame Mercury. There is no one to blame but the internet. All right. The internet be internetin'. Let's switch back and see if we can at least bump this sound a little bit. We'll bump. Let's just bump. Let's see if we can just make it work. We'll just do our best. All right. We will zoom this up until there's the phone disturbance, and that should get us to where we were. There we go. And fingers crossed.
One is entitled Digital Forensics Methodology Regarding Subject
I'm
Matter.
going to back this up just a little bit because that was a really rough interruption of the feed just abruptly ending. So I think if we have a little overlap, we're probably covered.
7:40 a.m. on
There we go.
January
We're probably
29th,
covered with a little bit of
2022.
overlap. Good Lord today.
Mr. Green, and I want to cover the baseline for this hearing first. Mr. Green testified at the first trial.
Yeah, we've got a little overlap.
He testified without objections as to his qualifications. He testified without objections to his methodology. Your Honor sat, obviously, and presided over that trial. Your Honor did not issue, after his testimony, any limiting or curative instructions with regard to either his qualifications or methodology.
He testified.
Nor did the prosecution, after his testimony, stand up and ask for any such limitations or qualifications.
There's our overlap.
The baseline for his qualifications and methodology was established.
And there's the phone.
Again, without objection. And
all right, I'm going to zoom. He pauses for the phone. That gives us our
the
overlap.
argument has provided now, but the reason I state that is because what Mr. Green has provided in response to this motion is even
No, that
more
wasn't again.
detailed than what happened.
Chat, that wasn't again. I was overlapping to find our place in the feed because the other feed ended.
The first trial.
But yes, at least there's captions here.
In Mr. Brennan's argument, he did not make one argument about Mr. Green's qualifications. Zero. So I'm assuming, because there's nothing in their motion
all the goat screams
that even goes into why he might not be qualified. So to me, Your Honor, that's a tacit concession, if not expressed, that he's qualified. And of course, he has to be qualified in digital forensics because there are 5 other areas of digital forensics opinions and methodology that Mr. Green is testifying about that has not been challenged. So to me, it is rather odd right off the jump that there's no challenge to 5 other areas of data forensics, and there's just this challenge to one aspect of his whole testimony and opinions. I have provided Your Honor with 2 exhibits demonstrative in support of my oral argument. Exhibit 1 is entitled Digital Forensics Methodology Regarding Subject Artifact, and Exhibit 2 is entitled Digital Forensic Product Tools Used by Witnesses. The Commonwealth has agreed to my use of those exhibits. They had some, I agreed to theirs, and I would like to, Your Honor, use those in a moment. The Commonwealth, in its oral argument, said 10 times just now that there's no methodology and that Mr. Green does not articulate a methodology. That is incredible to me because the opposition and Mr. Green's affidavit, in fact, are replete with the methodology. And here is the key, Your Honor. While Mr. Brennan challenges the methodology, none of his witnesses, neither Mr. Whiffen nor Ms. Hyde,
and that's
challenged
the key.
The methodology. As a matter of fact,
the defense argued this last time, and they're not wrong. It's to get this hearing, you've got to go beyond the attorney says so. You've got to have someone else say that. It's not just, well, the attorney feels like this isn't a proper opinion. It has to go beyond that. And the defense argued that last time when they were asking for the Dauber hearing against Russell.
In their 2 reports, neither of them even describe Mr. Green's methodology, nor do they challenge it.
Right.
And of course they can't, because it's the same exact methodology that they use. And that's what I would like to go to.
That's what I said.
Exhibit
they all do
1
the same thing.
Is entitled Digital Forensics Methodology Regarding Subject Artifact, J. McCabe iPhone Data. And I prepared this. This is just what's in our opposition. It's in Mr. Green's affidavit. but it summarizes what
Oh, yeah,
the
unless he's
methodology
pissed.
is that
This
we're
attorney is
talking about here.
pissed.
What is that methodology? Step one.
He wants to say, what is this
You
fuckery?
receive, and this is to answer the question about what is the proper interpretation of the artifact in question
Right, that's
that
the-
everybody agrees is the artifact.
Right.
Step one, receive a full
And
file
this
system.
is where I agree with Alessi. This issue seems very much to me to be the exact type of issue that is for a battle of the experts. There is digital data. It is run through different programs. Experts with different training came up with different interpretations for that data. That's exactly what a battle of the experts is. These experts interpret it this way, this expert interprets it that way, and then the jury gets to decide what makes sense. That's literally the point.
System image of extracted data from the Commonwealth. For example, the defense received it on a USB thumb drive. That's undisputed. If you look at the reports of Ms. Hyde, you look at the reports of Mr. Whiffen, they all say they received a full file system image of extracted data. So step
They all
one
had
in
the
the
same
methodology
file.
that everybody agrees to, everybody agrees that occurred. Number two, verify hash signature value of image file of data received. This is very important because hash values with regard to forensic data is extraordinarily important for it to be proper because it's the signature, the fingerprint that allows data forensic examiners to be sure that
overclocked.
the data that they're giving
That's better.
is sacrosanct. It is
I think that's better for
possible
y'all
for
too.
manipulation. The Commonwealth just said that Mr. Green has hurled several accusations without a basis, one of which regards the potential for manipulation of data. And it's remarkable that there is even an issue about this dispute. Mr. Green did put in his affidavit an unprecedented situation, and it is this. Mr. Garino, Trooper Garino, in his April 2023 report, which is an exhibit to our opposition, states that when he got the phone of Ms. McCabe, he used Celebrite UFED, a tool of Celebrite, to image the phone. And that's all he sent to the defense in the beginning. Why is that unusual? Because what happens in every case, without exception, is that the law enforcement
Well, we've got our own questions about Trooper Garino,
raw
don't we?
image, original data that has the hash signature on it. And the hash signature is an algorithm that produces, they call it, in this case, SHA-256. What it is it's a stamp of reliability that says, as soon as we got this data, we immediately processed it the proper way and put a hash signature so that there can be no contest. What the Commonwealth fails to tell the court, Your Honor, is
No.
value,
Okay.
and that
That's the feed.
leads any
Y'all that are local in Massachusetts, what's your weather doing today? Because all of the stream issues seem like the type that we get when there are weather situations.
proper data forensic investigator to question the integrity
Is it really
of the data.
cloudy? Crappy weather. Yeah.
If you turn to, Your Honor,
It is not
Mr. Whitman's
easy.
very long December 2024 report, which is Exhibit 1
Who said cloudy with a
to
chance of BS?
the Commonwealth's motion on page 3. And I'm going to read it
Cloudy, cold.
verbatim.
It's hard. The streaming
value
is
is
struggling. The streaming is struggling. And these, just so we can appreciate the technology, because I really do appreciate it, they've got a camera in court that is broadcasting to a broadcast truck that is broadcasting out to the waves. It is not always easily done from courtrooms, depending on how the weather is and depending on how the courtroom is. Today has been a rough one, tech-wise, not just for us, but for the feed streaming out of court.
Here's the key point.
But at least we have it.
However,
It's better than not having
this
it.
requires authentication of the original hash value, which is not possible with great key extractions, as the PDF containing the extraction hash value is unsigned. Therefore, this hash value could be used as a suggestion of authentication. That's all a fancy camouflage way of saying, Mr. Whiffen saying, I can't validate this hash value because of the way Trooper Guarino processed it.
This is the good stuff.
Do it, Mr. Guarino, Trooper Guarino, the right way when he got it. And why is this of concern? Add to this point that's conceding that the hash value in this data cannot be validated. How did the defense get this? When Mr. Guarino used the Celebrate UFED reader, all he turned over in the beginning was the UFED reader report. He didn't turn over the data, the full. So Mr. Green had to ask for the data. Then what happens, misstep number 2, Trooper Guarino only provides a PDF of the hash value. He used Gray Key, which was a mistake, because Gray Key, you can't get the original hash value. Mr. Green had to go back a second time and say, no, we don't want just a PDF. We want the full, full extraction.
Right.
Finally, after the second time, the defense got the full extraction. And that's
of course they
when
want
we
the full
discovered
extraction.
that the validation was improper. It's not Mr. Green that is coming up out of thin air with these issues. This is the job of a data forensic person, and the first principle is to see whether the data is valid. So not only does Mr. Green justify in his affidavit why there's a big concern over this, Mr. Whiffen concedes it on page 3 of his report. That starts, and I'm going to get to it, all the concerns.
Your Honor,
now
don't get me started.
About the data and deletions. But that's the foundation for it, and it wasn't caused by the defense. It was caused by Trooper Guarino, who didn't do this properly. And with regard to
We can only work with what they give us.
I want to go back to Exhibit 1. So, importantly, Your Honor, 1 through 4 of this methodology is undisputed by all of the data forensic persons. Mr. Whiffen, Ms. Hyde, and Mr. Green all agree on 1 through 4. They all agree that this is the methodology. Number 3, once you get the image of the file, each examiner,
any expert would agree,
saves the image to their lab storage system. Some use computer servers, some cloud storage. And 4, the methodology, you then process the data with appropriate tools. Nobody disputes that Celebrite Physical Analyzer and Magnet Forensic Axiom are 2 of the many tools that are available to use. There's a dotted line that I've put there, Your Honor, because 1 through 4 is undisputed by all 3 data forensic examiners. Number 5. And 1 through 4 is usually all one needs to do as a data forensic examiner. But Mr. Green went on to do more. Number 5.
Tell me
further
more.
processing
Tell
of
me
data
more.
as warranted, and he explains why it's warranted here with additional tools. So he then went on to use Sanderson Forensic Browser, ArtX, Belkasoft X, and then he didn't use iLeap, Ms. Hyde used iLeap. So it's important to line up the methodology. I just don't understand how it can be stated that there's no methodology stated. Not only does Mr. Green
when the
state
methodology
it,
is right there.
we prove undisputed that everybody agrees this is what the methodology is.
Right, all the
and
experts.
that is what is so flummoxing as to why we're even here.
Sir, we got to pause for that. We need to pause for a moment. Once we got to flummoxing, we had to take a moment to appreciate the use of the word. We need our moments where we get them. Flummoxing gets a pause for applause.
The methodology is agreed upon. What is disputed, Your Honor, is what are the opinions from when you apply the methodology.
I mean, my brain's been buffering all morning.
Tools.
His is definitely not.
So, interestingly, it is Mr. Whiffen who provided the most lengthy report in this motion. Mr. Whiffen only used
Did he whiff it?
2 forensic tools. He only used Celebrite Physical Analyzer and his own software.
He's the Celebrite guy.
That's it. What I'd like to, Your Honor, is ask if I could, please.
I mean, he's the Celebrite guy.
Turn to Exhibit 2, which is entitled Digital Forensics Products Tools Used by Witnesses. And I just want to make sure Your Honor has that.
Okay.
So I prepared this demonstrative exhibit to show the tools that all parties
Definitely
use.
flummoxed today.
And the purpose of this is to show how closely Mr. Green and Ms. Hyde match up with the tools used,
All of the flummoxing.
and how insufficient Mr. Whiffen and Mr. Garino are. So, if you look at the left-hand column on Mr. Green, and I color-coded it to try to make it easier, you see 7 tools used by Mr. Green.
Mr. Alessi, you're speaking our love language, sir.
You see
You're
6
flummoxed and
tools
color-coded.
used by Ms. Hyde in May of 2023. Many of her tools exact same as Mr. Green. You see Mr. Whiffen, who used really 2 tools, but to be conservative, I listed them as 3 because they're just different versions of Celebrite Physical Analyzer.
I think, to be
And then
fair to
Mr.
Whiffen,
Garino-
though, Whiffen's purpose of testifying was to explain Celebrite. Hyde was to do the rest of the analysis with the different tools. So I think Whiffen had a different purpose than Hyde did, which he is making much out of when maybe there's not much there. But given everything else that's going on, I'm not surprised everybody's catching the smoke. Like, everybody just gets it. It doesn't matter if that wasn't your job, but I understood Whiffen's job to be more narrowly tailored than that. And I think that's fair.
Garino used 2 tools. But
I'm not
here's what's
pausing for
really
Trooper Garino. You can give him the
important
smoke if he
and I think
didn't give you the hash
remarkable
values.
From this chart. Mr. Green did more, had a more encompassing and comprehensive review than any of the witnesses here.
Right. He used more tools.
And
That's
back
completely
to
fair.
Exhibit 1, he did 2 more steps in his methodology than everyone else. So 1 through 5 of the methodology, everybody did. 6 is analyze overall user activity, artifacts of interest, timelines of interest, and anomalies such as deleted data. 7, reporting as appropriate pertinent artifacts, other artifacts. For this motion, Mr. Green did 6 and 7, and no other witness did that. The issue in this case as to whose interpretation is correct is an opinion issue. It is not a methodology issue.
I need just make a note. We need Tamara Judge screaming, "It's like my opinion," on the soundboard. We need to add it. I'm making a note. We're making a note. It's getting highlighted. This is where we all insert the "it's my opinion." And that's why they are arguing a motion to see if there's even going to be a hearing. The defense is saying, look, this is what experts are for. They did it this way. They did it this way. They came to different conclusions. That's the point of having multiple experts, which is well taken by me because I agree that this isn't a methodology problem. I understand that everybody has used the same methodology and sometimes different tools. This is not a methodology issue.
And Mr. Green makes
This is an
that
opinion
very,
issue.
very clear in his affidavit that the difference is in opinions. Interestingly, on the very key subject of whether the artifact and the interpretation of it is a difference in methodology, a difference in application of methodology, or an opinion, which is not the subject of a Daubert Lanigan hearing. Opinions are not. Here's what Mr. Whiffen had to say about the issue. This is Exhibit 2 to our opposition. It's the June 17, 2024 testimony of Mr. Whiffen, page 1-10, starting on lines 14, the question. And what, if anything, did you find with regard to the web history artifacts? Answer, and this is Mr. Whiffen. So the 2/27/40 timestamp was correct insofar as that is the time that is shown within the database. It was indeed a deleted record. But the interesting thing was why the timestamp said 2/27/40. And I did some testing on this and discovered the reason why 2/27/40 was actually listed in the database, even though that's not the time. Here's the key. In my opinion, that the search was conducted.
It's my opinion!
So Mr. Green's opinion is, after applying the methodology that everybody agrees to, after using the same tools as every other witness for the Commonwealth used, plus more, Mr. Green's opinion is, to a reasonable degree of scientific certainty, that that search and that record that everybody saw at the time of trial at 2/27/40, House Long to Die in the Cold, Mr. Green says it means what it says. The search occurred at that time. Now,
The thing speaks for itself.
Commonwealth, in its recent reports, and they did this also at trial, they said, yeah, we see it, it's in there. Ms. Hyde said, I see it. It's not only in there in Celebrite Physical Analyzer. I used Axiom, just like Mr. Reed. Mr. Whiffen didn't use Axiom. Ms. Hyde said, and I'm going to point to it specifically, Axiom shows it as a 220, that search is a 224. In fairness to trying to get the best decision for Your Honor here, they disagreed, Mr. Whiffen and Ms. Hyde, as to whether that meant the search actually occurred at 2/27/40. That's the opinion that's disputed.
I'm not going to be able to keep yelling, that's my opinion.
To the issue
but
inaccuracy,
I feel it in my soul.
those witnesses diverted at the end as to whether what that
Dr. B is here.
timestamp showed, 2/27/40 a.m., did the search really occur then, or as the Commonwealth said, did it occur at 6:23 in the morning? Mr. Whiffen says it's a difference of opinion because he says it's my opinion. The Commonwealth in this motion tries to make it seem like it's an issue of fact, and that Mr. Green doesn't have any fact. Well, Mr. Green's got a lot of facts, and he also, of course, has an opinion. So what we have from these two demonstrative exhibits, Your Honor, is a statement of the methodology in Exhibit 1 that every witness agrees to. Not only is it Mr. Green put a methodology, but we prove up in the opposition that there's no dispute. What's interesting, Your Honor, and I think quite remarkable, is that neither Mr. Whiffen...
He was waving at the screen. You guys couldn't see him.
40-plus page
Bye, B.
report of December
Thank you.
24, nor Ms. Hyde in her December 24 4-page report.
I've never needed that
Neither
Tamara
one of them
soundbite more than today.
Say Mr. Green's doesn't have a methodology. They don't say we dispute his methodology. It's the Commonwealth's attorneys that are making that dispute.
Right. No
And
expert opinion.
that is not appropriate. It's got to be your expert And I think there's a reason why the experts of the Commonwealth are not talking about methodologies or saying there's a dispute, because it's objectively verifiable that there's not a dispute over the methodology.
I don't know. I don't know. I don't know. I don't know. I don't. I don't.
What is also important is what...
Sorry, I'm sorry, Mr. Alessi. Your argument is fascinating. You are advocating zealously. You are flummoxed. You are frustrated, and today is just todaying. And I don't even know. I don't even know. But again, he makes a very good point that this is opinion. The entire part of it is opinion.
Has happened since the trial. And what I want to do is give a baseline of the trial, because I think it underscores the two issues that Your Honor have in front of you: qualifications and methodology. And the qualifications, all I'm going to say about that is Mr. Green has 25 years of experience in computer forensics, and he has 18 years in digital forensics. And the 18 is only because digital forensics became a thing 18 years old.
18 years ago.
There can be no dispute, and I think that's
not 18
why
years old. 18 years
the
ago.
Commonwealth didn't really say anything about it.
Digital technology is an adult now.
If you lay down Mr. Green's experience next to Mr. Whiffen, Mr. Green testified 23 times.
I'm waiting. Mr. Green could be Mr. Whiffen's father, Your Honor. I'm waiting. He's been doing this longer than Mr. Whiffen's been alive. It's like the dramatic old lawyers that are like, in my 40 years of practicing law, I've never seen. I've been practicing since before you were born. He's getting into that realm of the I've been doing this. We'll
qualified digital forensic expert in 7 different states. Mr. Whiffen, he's testified in 2 states, one of which was here, and he does not have anywhere near the years of experience. Here's another very important point: certifications. Mr. Green lists 3 certifications.
Notice how he's not touching Hyde, because Hyde's also eminently well qualified.
Constant updating, and I just want to state a point about digital forensic experts. They're not like medical doctors where you see people with PhDs, etc. These are folks that keep updated because the computers change so much, so that's why you see such a great listing of Mr. Green in terms of his
Today the computers just want to kill me.
Certificates, etc. However, if you compare Mr. Whiffen's qualifications to Mr. Green, and I'm again going to use Mr. Whiffen's own words with regard to his qualifications on his June 7th, this is again Exhibit 2 to our opposition, his June 17th trial testimony, page 1-6. Question, and this is a question from Mr. Lau. Now, with regard to your education in this area, what, if any, certifications do you have? Answer, no specific certifications. I've done the Celebrite coursework since joining Celebrite, but other than the 3-week course in Ottawa, and then again the 2-week course in Ottawa, those are police training things when he's a policeman. I don't have the SANS training or any of that kind of training certification.
Right, he's the Celebrite guy.
Now, I am not here today to challenge Mr. Whiffen's qualifications. But how could it possibly be asserted that Mr. Green's not qualified if these are the qualifications?
Catfink, this is just facts. This is just facts.
With regard to what has changed since the first trial, and I think this is incredibly important with regard to the methodology inquiry of Your Honor. I went through on Exhibit 1 the methodology that everybody agrees to. But the court doesn't have to take my word for it on this demonstrative exhibit, because Ms. Hyde gives the best explication of the methodology that Mr. Green used because she used the same one before trial and at trial, but she's now narrowed it for purposes of a report, and I'm going to state and show exactly how. So Exhibit 4 to our opposition, Your Honor, is the May 2023 Digital Forensics Analysis.
Oh, Duchess, I disagree.
Report of
I think he's
Jessica
angry.
Hyde.
I think he's outraged. Based on his
And
filings, I think he's pissed
in
that he
that
has to make this
report,
argument because
on page
he's mad the motion is being made.
3, she talks about, under forensic analysis, that she used, it's the exact same methodology.
What are you, I thought you said Exhibit 4. Exhibit 4 is a transcript.
So I think he's mad that he has to make this argument. He's
It's a
mad
transcript
at the
of Ms.
Commonwealth's.
Hyde, but it's not a report.
He
Okay,
perceives
my fault,
audacity.
we have different
He
numbering,
is
but I'll go
mad
to
that
the
they're having to
transcript.
argue this
I'm gonna go to the
motion.
transcript,
He's
with regard to-
frustrated.
yeah.
I'm happy to look at the
And I
report
don't
if that's what
blame
you're
him.
referencing.
I'm
but Where
gonna
do
go
I
to the
find
report
it?
With the
now.
frustration.
Your Honor's already at the, I can do it either way. If Your Honor is at the transcript, I'll go to the transcript right now. This is the June 14 transcript, Your Honor, of Jessica
So,
Hyde.
Yes.
Thank
They
you.
are
So
not pleased.
we're just
Not pleased at all.
Please keep in mind that in Mr. Hyde's 2024 report, that Mr. Whiffin's report that is now before you, Mr. Whiffin only used in his analysis now Celebrite Physical Analyzer and ARCCA, his own tool. He only used 2 tools. Ms. Hyde, in her 2024 report, which I will get to, is now down to just using 1 tool, Celebrite Physical Analyzer, because she states that's the only one I was asked to look at. So the Commonwealth went and narrowed the request of Ms. Hyde to just Celebrite Physical Analyzer. And what is going on here? It's very obvious. The Commonwealth is ignoring, in its 2024 December reports, all the other tools. Even though those tools show this timestamp of 2/27/40 still,
Which I think
at that
is-
time, they now just ignore it and go to the Celebrite Physical Analyzer.
I think the Commonwealth asked for the updated opinion. This is what I've gathered from the filings. We don't have all of the expert affidavits, only the one from Green. But I think the Commonwealth did that for this motion to argue this motion and what is and is not in Celebrite, because her other opinion is still going to stand. She testified at the last trial. So I think it was to this motion. I might be wrong, but that is what I got from the filings as it went to this motion. I don't think it changes the outcome of this motion.
It's undisputed that Celebrite went back and changed it in the middle of the first trial with regard to one physical analyzer program. And then after the trial, the other physical analyzer program, they went and changed that and took it off. But in contrast, Axiom, that Ms. Hyde used before,
Right.
still shows the timestamp. It's undisputed that that's the case. And
Right,
it's
this is all opinion
undisputed
argument.
because they don't contest it, that Mr. Green went and looked at it in Belkasoft, Sanderson. He did a manual, he did a low-level analysis, and in every one of those tools, the timestamp still occurs. So now back to the transcript. Your Honor, I am looking at, the question of, and this is, again, a significant point, is it better to use more tools? It's common sense. That's what Mr. Green says. That's what Ms. Hyde did the first time, but
Right.
now all of a sudden she's down to just one tool that unilaterally removed the timestamp. So here is the page of the transcript of what Ms. Hyde had to say. Page 1-13, Your Honor.
Okay.
Into the transcript.
Line 4. Question, again, of Mr. Lally. Now, with reference to the tools that you use that you just went through, are those
This is her
fairly
testimony.
common tools? Are those tools that are commonly used within your industry? Answer, yes.
Yes.
And what are those tools that she talks about above? Starts on page 1-2. Celebrite Physical Analyzer. Magnet Axiom. Artex. iLeap, and I later used Sanderson Forensic SQ Lite. Those are four of the tools that Mr. Green used, and he used more. So her answer is, now with reference to the tools, are those tools that are commonly used within your industry? Answer, yes. They are commonly used digital forensic tools that are very standard for other forensic examiners to use on mobile exploitation.
Right.
It gets better for the defense. Next question, line 15. So different forensic tools, question, and why were you using the different tools? So different forensic tools have different capabilities and look at data a little bit differently. Skip down. Commercial forensic tools that they can only support so many applications, so they each work and support different bits of data. Here's the key point, line 22. This is Ms. Hyde's words, under oath. So it's important to use multiple tools so you can see the results from different data sets, and be able to compare those results and enhance those with manual analysis. Next page.
Right.
Question, and with respect to, and this will be the last question and answer, and with respect to using those sort of different variety of tools, Cellebrite to Axioms to Artex, etc., is that something you typically do as far as your normal process of documenting a forensic analysis? Answer. Yeah, that is very, very typical for me to process with multiple tools to ensure that I'm getting the most complete interpretations from forensic tools. Of course, you go beyond that with your analysis, but it's absolutely pertinent. And down below, he asked, can you explain the interplay of these tools in analysis? And her answer is strikingly the same as Mr. Green in his affidavit and in our opposition. Her answer, the Sanderson's tool, which Mr. Green and Ms. Hyde used, but Mr. Whiffen didn't, is meant to look at specific type of data structures called the SQLite database. SQLite databases are very nuanced, and this particular tool allows you to take that database and explore it at a deeper level than the other forensic tools allow. Mr. Whiffen didn't use the Sanderson tool.
Because he was only there for Cellebrite.
Ms. Hyde,
It's opinion.
in her report of 5/23, 2024, her first report, and I'm going to get to her report here, she basically goes through and documents this methodology, and she documents the use of those tools. And she also documents that she saw the House Long to Die timestamp 2/27/40 in every single tool that she used. Where she diverted from Mr. Green was her opinion as to whether that
Just keep
timestamp
saying it in your head.
occurred at that time,
It's my opinion.
or did it occur sometime later. That's an opinion issue again, and Mr. Whiffen agrees in its opinion issue in that regard. So now let's
Unless he's
come
like, I'm gonna
to
give you
where we are
all
for
of
this
it.
motion and what was
All
submitted
of it.
by the Commonwealth. And I want to first go to
Tiana, Alessi's not
Ms.
happy
Hyde now.
at the audacity today. He's just like, why are we even here? So he is orating loudly today. He is having a
Exhibit
moment.
4 to the Commonwealth.
But yes, he is mad.
Motion.
But he's
And it's
very
entitled
logical and
Digital
easy to
Forensics
follow.
Analysis report.
But he wants the court to feel the audacity.
And there's been much said in the Commonwealth's argument this morning about allegations made by Mr. Green, which are all supported. Every single one supported with facts. But what the Commonwealth didn't tell the court is what the request was of Ms. Hyde. I just went through all the tools she used, why she used them, why she said it's best practices, why you use all these tools.
Right, because there's no
What does she
There's
do
no
now in
dispute
December of
on that.
2024 to assist in the myopic approach of the Commonwealth to say, here's our studies, we only look at Cellebrite Physical Analyzer, and it's gone. The search is gone, right? And we know why it's gone, because Cellebrite, Mr. Whiffen, concedes that he went back and talked to the researchers, and what we have, Your Honor, is a total black box. And I'm going to point it out in a moment. Why is this no longer appearing on Celebrite Physical Analyzer? We don't know the answer. All that is stated is a bald conclusory statement that it's no longer reliable. That's it. We don't know why it's no longer reliable,
Right.
but we know it's gone. And Mr. Whiffen never says, even though it's gone in one, he doesn't even address the other 4 or 5 tools, where it still appears. It still appears. Now
Celebrite said this was a misinterpretation of data, but then they have to explain that.
Look at the request, please.
Right.
The request was to understand changes made in newer versions of Celebrite Physical Analyzer to artifacts pertaining to the timeline of a Google search
again.
on January 20.
That was me. I was going to try to answer something in the chat. That time, that was me. Oh, today. You know, streaming is going to keep you on your toes, chat. It's just like, good morning. I don't know what's happening.
29/2022.
That was worse than it normally is today.
Die in cold.
Ugh.
That
I know,
is stunning.
y'all.
The request.
He got brutally interrupted by me.
3. Look at the request, please. The request was to understand changes made in newer versions of Celebrite Physical Analyzer to artifacts pertaining to the timeline of a Google search on January 29, 2022, namely, House Long to Die in Cold. That is stunning. The request to her was simply to look at one tool that everybody knew by then Celebrite had deleted in their program. She then looks at evidence analyzed.
And I think that's for
second
trial
paragraph.
to explain.
This full file system image was processed with Celebrite Physical Analyzer, version blah, 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 decoding engine, etc. Where is her analysis of Axiom that was in her May 2023 report? Where is her analysis of Sanderson? Where is her other analysis that if she went and did it, she would have to say it's still there? So what she goes on to say is very interesting, but it's buried, and here's what it
Alessia's
is
drinking
on
black
page
coffee
4.
and rage today.
After she goes through and states what everybody knows is Celebrate just went back and for some reason deleted it.
Well, they told us why.
She says under the chart, while manual analysis of the database still shows a 2:27:40 a.m. ET timestamp,
Ashley
the
McClurk, I'm with you.
determination in prior analyses and from Celebrite is that this timestamp does not demonstrate that the URL was visited at the time of the last visit timestamp. So here she did a manual analysis, and it still shows up, but she doesn't explain the significance of that. If we want to talk about reliability, Your Honor,
Let me tell you, Your Honor.
the real question should be the reliability of the prosecution's witnesses in Celebrite Physical Analyzer.
So are you telling me that we should have a hearing?
Your Honor, there's no need to have a hearing, and here's why. There's no
Your
need.
Honor, now is not the time to try to be funny. He's like, let me tell you about reliability. I'm not reliable. You're not reliable. The judge is like, does that mean you want a hearing? No, he doesn't need a hearing. Now is not the time, Your Honor.
For a hearing because there's no disagreement on the Daubert issue.
It's the question is, are we almost
dispute
done,
over
sir?
what is the
This is all in your
interpretation of
motion.
this data, what are the
This is
people's
not
opinions,
what she
is
likes
never one
from
for
oral
Daubert.
argument
if
at
that
all.
were the case, there'd be a Daubert hearing on every expert.
This is not
because
the
experts,
type of oration
almost
the court
by definition
prefers.
on each side,
She is-
disagree on the opinions.
This is
we
all
don't need a hearing,
in
Your Honor,
their filing
because
papers.
they agree on the methodology. They agree that more tools are better. They agree that the difference is at the very end of the analysis, which
At
is
the opinion.
So in terms of the
Say it with
issues
me.
with regard to
It's
Mr.
my
Green's
opinion.
report, which is my final point to get to, There's been so many mischaracterizations by the Commonwealth.
He's letting the
this
court know
morning
he's
of
wrapping
what
up.
Mr. Green did and what he said. So what does he do? He says, and Your Honor, digital forensic analysts are the equivalent of a medical examiner. Their job is to apply the methodology that is agreed to. Their job is to use the tools, everybody agrees on it, and then they're to give opinions on what those mean. And everybody here has the same data, right? Everyone's got the same data that they're using, so there's no dispute over that. The Commonwealth said that there's no factual basis for what Mr. Green did. There's a factual basis for everything, and it's undisputed. So everyone has the same data, and this I call the NB postulate. And the NB postulate is, why are people using different tools, etc.? Is because nobody has the source code for the Apple phones. So you use these tools
right, 'cause Apple.
to try to help interpret what these source codes mean.
Right, because Apple.
And it's an accepted methodology to do it. But the data, once it's produced, and we have an issue about what happened before it got produced, but in terms of the methodology that was applied here in the tools, there is no disagreement. So what, Your Honor, would an evidentiary hearing do? We're just going to come in and have witnesses talk about their difference of opinion? That's not what a Daubert is for.
Right.
There's no basis for an evidentiary hearing because there's no dispute over the methodology. I've done a lot of Daubert hearings. I've never even gotten past a motion, let alone an evidentiary hearing, where the experts don't disagree on the methodology.
Right.
So what is it that caused Mr. Green to raise questions? And again, I said data forensic examiners are just like the medical examiners. They don't look at just the body of the medical examiner. They look at circumstances surrounding it and all information. Well, that's what digital forensic examiners do, and that's what Mr. Green did. So there was great criticism of Mr. Green from doing what is proper for a digital forensic person. And it's a bit of a camouflage, respectfully, because the December 2024 reports of the Commonwealth now myopically go down to just
we got to
one
myopic.
tool.
Okay.
So what did Mr. Green say that caused him to say, I think it strongly suggests that there's been manipulation here? He used the fact that there's no hash value for the data. That's conceded. And when there's an issue over hash value, every single digital forensic expert is going to raise concerns about the validity of the data. And Mr. Whiffen is one of them who did that. Secondly, what Mr. Green pointed out on the issue of was this search deleted, there were 4,056 searches on the phone of Miss McCabe. 4,056.
That's a lot of searches.
There was one deletion out of 4,056, and guess which one it was? House long to die in the cold. There are no odds that that can happen randomly, that one search out of 4,056 is deleted. So what does Mr. Green say? He says that strongly suggests
The other experts
one
say
of
the
two
search
things.
wasn't deleted.
Either there was user
They say it didn't write
interaction
to the wall
deletion,
file.
or there was post-imaging manipulation
That is
of the
what he
data.
says.
He doesn't accuse individuals. He says user interaction or post-imaging. That is the job of a digital forensic person, to point that out and say that raises concern. The fact that there's only one deletion of a search out of 4,056, I think it's malpractice if a digital forensic examiner doesn't point that out. Another key thing he points out is an anomaly. The Commonwealth said there was a tab number for ARCCA Sports, and that they said it was the same tab number for how long to search or how long to die in the cold.
They said that.
But Mr. Green points out that's incorrect. They had two different tab numbers. So that theory of the prosecution can't be right. So Mr. Green wasn't hurling accusations. He was doing what data forensic examiners do, is pointing out all these anomalies. These aren't things you normally see, and they're not explainable. Here's the last point I'll make, which there's also agreement. There's this deletion of this one search. Mr. Whiffen can't explain why. He says, well, maybe it was a spontaneous deletion. There's no such thing in data forensics as spontaneous, and he doesn't cite any. Maybe it's because
spontaneous deletion.
Low. Maybe it's because there was bad connectivity at where this search occurred. Well, that's interesting because a harder thing to load, the image that came up with food, did load. So you got to have stronger connectivity to get an image that dense. So what Mr. Green simply points out is that doesn't make any sense either. That is the essence of Mr. Green's affidavit. And Your Honor, just to be clear, when we sent in the second affidavit of Mr. Green, we put in the cover, and Your Honor may not have gotten this, that it was to replace the first affidavit because there were some typos, et cetera, et cetera. So you'll see two dates of the affidavits, and it's the later date, and I'm going to give you the specific one that controls.
No, I have both.
Okay,
but
right.
Yeah.
The second one on the body of it does not say it's a supplemental or anything. If it was in the cover letter, that's what they're both docketed, so they'll both remain docketed.
I was just going to say, we wanted to have them both there for whatever purpose Your Honor wanted, but there's been some question about why two, and it's a simple explanation, one supersedes the other. So, Your Honor, in terms of, and this will be the concluding part of my remarks, in terms of the allegation that Mr. Green relies upon technical support at Axiom, and he relies upon technical support of Axiom, and a statement that is just remarkable, that's the basis for his expertise. Mr. Green makes very clear that he did his own analysis, he used the tools himself, but here's why he called Celebrite. At the time of trial, Celebrite had two versions of physical analyzer on the market at the same time. One physical analyzer 7 showed the 22740 timestamp. It showed it, and it showed it in a deleted state. But the recent one, the one that Celebrite updated 1 week before trial, didn't have it. So that was the Insights, spelled oddly, INSYETES. That didn't have it. So Mr. Mr. Green did what any good digital forensic person would do. He called up support and said, well, what's going on here? You got one that shows it, you got one that
support
doesn't.
is not.
But he did what the NIST standards, the National Institute of Standards, and that's attached to Mr. Green's affidavit.
Him calling
says
support
that
doesn't.
Good digital examiners use multiple tools, and when they have questions or they see anomalies, you call up the program people. You talk to their technical support. That's not someone inexperienced and relying upon them.
Right.
That is the proper methodology. So Mr.
Your program
Green
showed
did
this,
that
now it shows this.
to corroborate
What is it?
and get explanation for what he found.
Right.
So in sum, Your Honor, here is what is before the court and what is pertinent for this motion. What is pertinent is the inquiry under Polk, which Your Honor cited in your decision on Dr. Russell. It comes down to, is Mr. Green qualified? There's not even a contest. Second,
They want to just
Is
exclude
his
certain
methodology
opinions.
reliable? And Your Honor, those are the only two subjects that are ever proper for a Daubert hearing. Why would we have what will be a very long hearing? Now, Mr. Brennan suggests bringing in Mr. Whiffen. I've never heard of that happening in a Daubert hearing, where one party challenges the witness of the other, and then says, and oh, by the way, I want to bring in my witness to show. That never happens in Daubert. It's the person who...
I wouldn't say never.
Well, let me take that back.
It-
Good
right.
point. I won't say never. It is
It
so
can
unusual
happen.
to have
It's-
that happen under these circumstances.
That
and
is
this
accurate.
Is the key, Your Honor.
What he's arguing, and again, they're having a meeting about whether they're having a meeting. The prosecution is saying we need to have a Daubert-Lanigan hearing like we saw with Dr. Russell. The defense is saying this is a difference of opinion. That's not the proper use of this hearing. That's not what the hearing's for. There are times where if you are trying to get to what a methodology is, you will have experts say, this is not a methodology. So you would have the prosecution in this case bring in an expert to say, the defense expert said this, that's not the common and scientifically recognized methodology in the field. And then the defense would bring in their expert to say, no, this is the methodology in the field. So it's funny that he's arguing this to me, because at the last hearing, the defense argued, look, the prosecution didn't even bring in an expert to say that Dr. Russell's methodology isn't proper. So the defense argued the other side of this at the last hearing, saying, look, the prosecution doesn't have an expert to say this isn't the proper methodology. And the Commonwealth here is like, well, we're going to bring in an expert to say that this isn't the proper methodology. And then the defense is like, who would even ever do that? Counsel, you argued that at the last one. So the defense is saying to the court, you would never bring in a second expert, and you would in different circumstances. In this case, they're not really fighting over methodology, is my perspective as well. So we're not looking at an argument over methodology here. And that's really what he's getting to, is that this isn't an argument over methodology. This is an argument over conclusion and opinion. And that's the purpose of an expert. So that's why the court's like, well, I would never say never, because that's what happens.
Why would we have a hearing about whether his methodology is proper
When that's not
and
the argument,
reliable
right?
If all of the witnesses agree what the methodology is.
Right.
So, Your Honor, in conclusion, I would urge the court to deny
Everyone applied the same
motion
methodology
of the Commonwealth to exclude Mr. Green on one of 6 data forensic issues. He's going to be testifying, obviously, at this trial. And
Obviously.
I would urge Your Honor to not have the evidentiary hearing, because Your Honor has before you everything Your Honor needs to perform the gatekeeping function. And again, it's almost all undisputed, with exception of one
of
thing,
the conclusion.
and that's the opinions of the expert, which is never proper. I will respectfully state that never is appropriate for a Daubert hearing. Thank you.
I agree with that.
Okay. Any follow-up, Mr. Brennan?
I do.
Oh, all right. Brennan is going to give his final thoughts, because he bears the
A little bit
burden.
of knowledge of forensic data analysis can be dangerous. So when you hear representations or arguments that
Your
Mr.
argument is a little bit of knowledge is dangerous, Brennan.
Whiffin's opinion that there may have been a connectivity issue is undermined because there was a picture of food which is suggested through a application search, misunderstands the basic premise that that's a cache picture. And that is meant for the user of a phone, for the user experience. And so there is cached items that
If
are
it's a
available
cached
without
picture, it
connection
is
that
different.
register and come up quicker from a different source while it's waiting for a search to be conducted. It's simple. It can be explained. It's science. It's data.
But
So
again,
when you take a little bit of data
opinion.
and you twist it because you misunderstand it or you want to advocate, that is the danger, and that's why it's best left to experts.
But
What
again,
the defense apparently is mistaken about is that using a number of tools does not substitute for methodology. You can use one tool, you can use 30 tools. They're all going to say on the timestamp that how long to die in the code occurred at 2:27 on that browser. That is the time that was opened. That window was opened at 2:27.
And that is an expert
But you
conclusion.
can't just look at 8 different tools that are all going to say the timestamp is the same. You have to look into
And then your
the
experts
data,
should be
and
able
into
to
the
say that.
databases, knowledge C, the history, and you have to determine what artifacts exist to show that occurred at that time. And when you do that in this process, it is clear
Sir,
that
if you want everyone to look at the databases, can you please just clarify why your expert narrowed down their scope of search when you had them submit an affidavit regarding this motion? Because I'm curious about that.
27 search counts.
Thanks.
Back to
We'd love to hear it.
1620. And so that's what Mr. Green doesn't do. He doesn't engage in methodology at all. There's an agreed methodology. He doesn't use it.
What's the agreed
The defense
methodology?
points to Ms. Hyde's report, how it's narrow. It's narrow because it's
Oh.
in addition to her 2000.
Okay, fair is fair. Fair is fair. Answer the question we want to have answered. Look, we didn't use all the words we love, but when I said, "Can we please answer this question?" then he goes into that part of the argument. I'm not mad at that. I'm curious.
An agreed methodology.
I don't know if I'm going to agree
He
with
doesn't
you,
use it.
but I'm curious.
The defense points to Ms. Hyde's report, how it's narrow. It's narrow because it's in addition to her 2023 report.
That's what I
Mr. Green
thought.
has not written a report. He has not provided data.
Really?
He has not provided that he has used methodology. He has not engaged in the process of studying the data. He made a couple of phone calls.
Wait, did Green really not make any report? Counsel, really? Only the affidavit?
And so you can't simply look at the timestamp and then give a reckless opinion not based on the methodology.
Still an
We still
opinion.
haven't seen a report from Mr. Green. There is none.
That's
Because
interesting.
if he actually does the testing and takes a phone and tested his hypothesis, he would dispel his own hypothesis. And if he doesn't do that, we'll do that for him.
Well, that
There is
is
no
also
hashtag
opinion.
concern.
But no
And
report
when
is...
the defense raises issues, postures, ideas. We never hear.
I don't love no
what's the problem.
report.
What is the hashtag done? Who manipulated it? And that is the MO. Blame anybody. Don't articulate who.
I mean, they're the
Be
defense,
like a
though.
ghost, evasive as possible, and then when it gets knocked down, just posit a new theory. The government offers to bring in Jessica Hyde next week or Ian with him at another time. Is it common? No, it's not. It's because the government has no fear of a hearing to help educate the court on the data science that is at play here. And so while we don't need to, we have no reluctance to. So there is a.
I think you do need to if you're
on the fallacy
if you're
that-
attacking the methodology. I think you do
So
need
we're
an expert.
happy to do it. We welcome it.
I think this is opinion.
Okay. Did you want to say anything very briefly, Mr. Alessi?
In 60 seconds or less, Your
Okay.
Honor. Thank you for the
Clock it,
opportunity.
Mr. Alessi. I want to hear about the report,
The
Alessi.
Commonwealth said a little knowledge is dangerous. I don't know what a hashtag is. I've never heard of what was just said as a hashtag. It's a hash value, and it's a very important
meant hash
concept to
value.
get right.
Right,
With regard to
right. A little knowledge is a dangerous thing. And then you get up there. I thought he said hashtag instead of hash value. And then you get up there as counsel and step on yourself. And then he's like, right. I don't even know what a hashtag means in this context. It is a hash value. Look, man, if you are going to try to out-knowledge the other side, you can't get it wrong or you are going to get smacked with it. And of course, Alessi's going to stand up and take the opportunity to do that. And I don't blame him because that Hank, Brennan's sitting up here being like, their expert spelled gray key wrong. And then you get him standing up being like, Your Honor, what is a hashtag? Sir, are we talking about hash values? And yes, I see Yannetti's got a little bit of smirk. I will back up if Yannetti grinned, because of course he did. Because of course he did. Because you're going to say a little knowledge is a dangerous thing and then completely fuck the rest of it. It's not going to go well. I rewound.
I've never heard of what was just said as a hashtag. It's a hash value, and it's a very important concept to get
Yannetti's
right. With
not
regard to
unhappy.
the whole premise and point of my argument, Your Honor, that this is a difference of opinions, it was just made by the Commonwealth Foreman. What was said, it's alleged that Mr. Green has reckless opinions. My point exactly.
Their opinions.
Take away the reckless. They're going after his opinions, and it's been stated now by the Commonwealth
Use
itself.
their words.
It's the opinions, and those are not proper for a Daubert hearing. Thank you, Your Honor.
All right.
Wise, Alessi, wise. And Chet, I agree, hash browns do sound good.
Thank you.
Wise.
So it sounds a lot like it may just be a disagreement in opinions.
Yes.
But,
Yes, that's exactly what the fuck it is. It's not what it sounds like. That's what the fuck it is. That's what the fuck it is. That's exactly what it is. Are we all on the same page, Your Honor? Because it feels like maybe we're all on the same page. I think this is as close as we've seen to this judge being ready to make a decision, but she's not going to. This judge does not rule from the bench. She's mostly there and is going to sit down and be like, I just want to review it one more time. And that is very much how she does things. So let's hear what she has to say.
Thank you, Your Honor.
all right. Well,
I think
There are 4 exhibits that have been marked.
thank you.
I think the court,
So it sounds a lot like it may just be a disagreement in opinions, but
she wants to look at it.
for the Commonwealth, I will look more closely at your methodology arguments that were made today. If I decide that we need a hearing, an evidentiary hearing, and that I cannot decide this motion based on everything before me, I will let you know no later than Monday. Okay? So we'll keep next week, and I'll let you know.
She, I imagine, is not going to have a hearing. She is hearing
Not
from
that
the
I would
Commonwealth.
exclude something simply because
She is hearing from the Commonwealth. She is going to look at their argument, but I think that we're probably going to end up with no hearing on this. All right, let's see what we're going to next. We got to talk about the defense's motion with regard to costs.
next week, and I'll let you know. All right. So, and not that I would exclude something simply because it takes a lot of time, but we really need to make sure we keep this case on track for the April 1st trial. So I have a question for the Commonwealth on where we stand in discovery, and then we're going to talk a little bit about the motion to recover expert-related expenses.
I want to hear that.
Your
This
Honor,
judge,
we've
for those of you
been
asking in the
discovering-
chat, I have never seen this judge rule from the bench, ever. I've never seen this judge rule from the bench, not once. Not once at all.
We've gone along to try to give the
It is
defense as much
not how
notice
she does
as
it.
we can. I had anticipated having discovery finished last week. We've sent over most of our discovery last night, or it's in the process of being turned over. There is one further report. We've retained Dr. Wilkes as a neurologist. I'm waiting for his report.
Really?
He's away. And so my expectation is I can have that report by Wednesday.
Okay.
Further, there was a witness interview earlier in the week. I'll have that report as well. My Rule 14 commitments are ongoing. They are involved. Enormous amount of time over the months has been spent trying to satisfy that I can account for all the discovery and make sure the defense gets everything that I can as soon as I learn about it. We'll continue to investigate this case all the way to trial, but our discovery should be completed by Wednesday.
Okay. Does that include the analysis of the data from the Lexus?
Ooh, I wanted to know about that too.
That has all been turned over, or we're sending it over on link. Is something like 8 gigabytes on my expert, so it takes a long time
Really?
to download. It was all sent to us yesterday. That's all included.
All right,
The
so-
analysis is done. The accident reconstruction is done. Mr. Crosby was
They did another accident reconstruction. So if you didn't catch what Brennan said, he said that their Rule 14 discovery obligations are ongoing, that they have turned over or are turning over all of the new information from the Lexus, including 8 gigs from their expert. Because remember, they were trying to like chip back on the chipped off Lexus to try to do another extraction, because the first people were like, I don't know how it's going to work, and we just don't really know how to extract things out of a Lexus, and we'll just try. And then a witness interview, that doesn't necessarily mean that there's a new witness. That could be a new interview of an existing witness. But they also said that they finished up their accident reconstruction, which indicates to me that they have decided that maybe Trooper Paul is not going to be their accident reconstruction expert at the retrial. Are they allowed to bring in new experts? Yes, they are. So as the court goes through this final housekeeping on where we are with discovery, we are learning more about the fact that new prosecutor has come in and is going to be bringing in new experts. So let us continue. And yes, they are allowed to do that.
Expertise in bites and dog bites, his reports are in. Ms. Hyde and Mr. Whitman have further reports that have been provided. Ms. Hyde has one more that's outstanding. We may have it. I expected it last night. I have not reviewed. And I think that accounts for all. We've been through the entire amount of discovery that was prior. It has all been Bates numbers. It hadn't been before, and it's marked as previously provided.
The fact that we are getting ready for a second trial and Brennan is standing up there saying everything has now been Bates numbered and it wasn't before. It is just one of the most basic standards of especially a death prosecution. Would it be great if everything was Bates stamped? Sure. Is it not always needed in a case where there's 3 reports? Sure. Report 1, 2, 3, however many pages. The fact that the entire file was not Bates stamped is so fucking annoying to me. I just can't wrap my head around how you try a case and you don't just start Bates stamping it from the beginning. You have investigators. I mean, I guess maybe now I understand why after we saw the first trial, but you have investigators that should be Bates stamping everything from the beginning. And for those of you that are like, Emily, what do you mean? Bates stamping is additional numbering system so that even if the report is report 1, number 1, it will have a Bates number. So everything has a number and that it's sequential. And that if the prosecution is like page 101, 102, 117, yo, we're missing something. Where's the middle bit? It's not hard to do. It should be done no matter what. Like, what are you doing? It just stamps the pages so everybody's on the same page. I mean, I guess it's hard to Bates stamp a Stop and Shop bag, but it just has to happen. The more I learn about this case, the angrier I get. Emily, tell me how neurospicy you are. There's a process to be followed and you're not following the process. Why? This isn't hard. Just follow the process so everyone's on the same page. If you want to bring a prosecution, just do the job. I can't believe it wasn't done. I can't believe it wasn't done. I can. After everything we've seen, I can't believe it wasn't done, but I'm still so annoyed that it wasn't done. And it's why when the defense comes in, they are so frustrated because it's been years of them being like, and now there's new video, and now there's new this, and now we didn't have this, and now we didn't have that. It's not how it's supposed to be done. And it's not just one thing that fell through the cracks. It can happen. It's not just a one. It's so many. All right, we're going to continue. I can't believe, and the slight shade from Brennan here being like, we finally bait stamped everything because it was never done.
We've been through the entire amount
Good
of
Lord.
stuff that was prior. It's all been Bates numbered. It hadn't been before, and it's marked as previously provided. I've made a very, very thorough accounting analysis with help of all of the information that isn't in those Bates numbers and provided everything that I've come across as soon as I come across it.
All right.
He's had to reevaluate the entire file to make sure everything was turned over.
Through,
Of course, you would have to.
There was an issue regarding a phone that we hired a third party to look through the phone and produce all Rule 14 discovery. I mentioned that my position was that it was a very broad view that the assessor should look at. I was uncomfortable reporting to the court that the phone had been reviewed.
What phone?
By somebody else, so I did it myself. And so I've gone through the entire phone, every email, every page, thousands, and I've provided not only Rule 14, but a broad discovery.
Oh,
This
probably
was
Proctor's
checked forward
phone.
this morning to the defense, so they have
Unless there were
anything
others.
that from my
You guys are saying
perspective,
Morrissey's
my
phone?
experience, would be remotely important or interesting to them. Also, I've gone through, well beyond my obligation, emails of members of the District Attorney's Office, and that continues, and I have another production as well. I wouldn't call it Rule 14 because it's not necessarily statements of witnesses, but again, I've taken a very, very liberal and broad view of what I would potentially want if I was defending the case. And I've provided that again under seal today.
All right.
And so we do not have an official discovery order, but I'd like the defense to have their discovery be 30 days after I complete mine, which will be next week.
Okay.
That was me, not you.
We filed, but I did not see on the docket, or we sent in, we did not file a motion for clarification, and Your Honor did not mention that. That's an important notice that we had sent in because I am greatly respecting the April 1st trial date, and there is work to be done. And so I would like to address that motion.
There should not be this much work on a retrial.
Okay.
Truly.
All right. I'll need some time to review this, obviously.
For those of you asking in the chat, and I saw a lot of questions. Why would he go through it? He said, I went through it to make sure everything was turned over to the defense and took a broad view. It was I didn't trust anyone else to go through it and turn over what needed to be turned over in the view of the court. So he said he reviewed it himself to make sure that what was turned over is turned over properly. That's not, I don't think that's being odd in any way. I don't think that's inappropriate in any way. I think he is in this trying to say, I'm trying to make sure they have everything that they're supposed to have and taking seriously the discovery obligations here. And while I don't agree with all of the arguments he has made in court, him personally going through and making sure everything is turned over is what's needed if there's a concern that things aren't turned over. And in this case, there has been numerous concerns that things weren't turned over.
Okay. All right.
Lots of concerns.
That's great. So the Commonwealth expects to be ready for trial April 1st.
Yes, we do.
Okay. All right. So now let's just take a look at a preview, if you will, of the defendant's motion to recover expert-related expenses from the Commonwealth.
I've been wanting to hear about this. So we're going to take a quick pause, very quick pause. This is the motion that I went over on Tuesday. I don't know. This week has had 100 days in it. So Tuesday is when I went over it. Karen Reed's attorneys are asking for a little bit more than $12,000 of fees with regard to their expert because their expert went to Canton PD to get a forensic extraction of the DVR system at the police department that showed the Sally Port and other things, and showed up and we're told that the limit does not exist. The video does not exist. Why are you even here? So they spent all this money. It was represented to them that they could extract that directly off the DVR system. And then they walked away with nothing. So the defense is like, our client shouldn't have to bear the cost of this. Also, WTF that you say it's there. You say our expert can come. We show up. It doesn't exist. And the expert is just like not the expert, the Commonwealth's digital person was like, I don't know. I don't know. So when the Commonwealth represented that they could extract original data would have been the time to maybe say, hey, the original data doesn't exist. Don't fly your expert across the country to do this. So that is why the defense motion is on the table. The defense indicated in that motion, sorry, my in-ears are pulling down the back of my sweatshirt. The defense indicated in that motion that they would later be bringing a motion to dismiss. There will be lots of questions about what wasn't turned over, if evidence was destroyed. The defense is going to bring a further motion. That's not on the table today. On the table today is an initial conversation about what happened. I don't even think the Commonwealth needs to respond in writing to this. I think Brennan just needs to stand up and explain what happened. I still think the money should be turned over, but we will see what happens. I have been very curious if the court would address this today. And I think on Tuesday I said, I didn't think the court would address this today. So I'm actually pleasantly surprised that the court is going to open up a conversation about it. I was much more convinced that the court was going to say, we'll let the prosecution respond and we'll bring this up in a week or two. So I'm, again, pleasantly surprised that the court is going to entertain a conversation about this today. Yeah, I want to see the motion to dismiss too. It hasn't been filed yet.
Opposition that
they must have filed it today.
We're not going.
Emily, keep reading. So the Commonwealth filed a written opposition today. So we'll see that next week. She's not going to rule on it today, but at least she's allowed to, or at least she's having a conversation about it.
I'm going to hear this motion today because I didn't have the opposition. But one of the things that I'm hoping you can tell me before we hear this, all right, there are a couple of things. Let me just, in this motion,
I'm
there's
glad
a
she's bringing it up.
that references, so this motion from the Commonwealth was filed, from the defendant was filed on January 23rd. So more than a week ago, and the motion, I believe, is a footnote that highlights a pending motion to dismiss. I need that motion to dismiss. We need to get this moving. When will that, well, I'd like that filed next week so we can hear it next week.
No, Your Honor.
We haven't.
I am traveling next week.
Analyzed it.
I just, no, just, no, not next week. Can we?
Motion to dismiss. We need to get this moving. When will that, well, I'd like that filed next week so we can hear it next week.
The reason that we haven't finalized it, the reason we haven't put the full contours on that motion is because we haven't received all the discovery. And I think it would be premature for us to figure out exactly what the parameters of our motion
Get it, Alan.
are until we know exactly
Yes.
what is putting in front of us in terms of the second trial.
Am I picking Alan's side because he's right on this? No, I'm picking Alan's side on this because it works best for my schedule. He also happens to be right, but I'm taking Alan's side on this because it works best for me personally because it's all about me. No, I'm teasing. Alan said we need the rest of the discovery before we can make that motion to dismiss because we need to know what else is a problem, and that is fair. And the prosecution said they'll have the rest of discovery next week, so it needs to bump out at least a week.
But as soon as we get that,
That's fair.
we think that we have the grounds.
That's completely fair.
To bring that motion relatively quickly thereafter.
So you expect to have everything to the defendants by Wednesday?
I do, and really what's missing is a report from a neurologist, a witness interview that is really inconsequential, and Ms. Hyde has a report regarding a phone. That's all that's really left for discovery.
Well,
so
they need to know.
that's all I can say.
All right, so if you get it by Wednesday, we're here Thursday and Friday.
No,
I'd really
Your
like
Honor,
to see.
that's unreal. No. Asking them to get all the discovery Wednesday and file a consequential motion to dismiss by Thursday isn't it.
Something by Friday. You've obviously been working on it, even if we end up having to do it in piecemeal. So
we've been thinking about it, but we have not. I mean, I don't know what you mean by working on it. Yes, obviously, we're working that direction.
No, Your Honor.
There's no way for us to reasonably get that done by Friday. That's just.
Yep.
There's so many other things that we're dealing with.
Yep.
Including hearings like this that
Yep.
keep coming up over. And
Look at
over
Alessi.
and over.
Alessi's like,
I'm not.
I'm going to stop interrupting Jackson, but Jackson's like, Your Honor, if we didn't have to deal with this bullshit today, maybe we'd have more time. But no, today we're dealing with the bullshit. Jackson's not going to back down, and the judge is going to have to give them adequate time on this because it's not a small issue.
There's no way for us to
Right.
reasonably get that done by Friday. That's just. There's so many other things that we're dealing with, including hearings like this that keep coming up over and over and over. I'm not. The court knows we don't drag our feet. As soon as we get something, we act on it. I just can't promise that we could get it done by Friday.
I think that's unreasonable.
We're not.
So
There's no strategy for us waiting. I promise you.
be prepared to discuss it next Friday. I will be looking for it very shortly thereafter, and we will have a hearing on it very shortly.
Just set a hearing date. Just set a hearing date.
Time to respond.
Understood.
So we need to come up with a scheduling order, or I've got a scheduling order that we need to discuss. But regarding this motion, what I need to know before I hear the motion on the expert-related expenses is what.
This also indicates to me that the judge is not going to grant the Dobbert motion, and this is why I'm reading into that. The judge is planning. Here's what I'm reading into what the judge is saying, just based on my experience working in court. The judge is now sitting in a different assignment than she was when she had this case and has a docket full of other shit that she has to do too. The court has put aside a day for that Dobbert hearing, and now the court is trying to fill in other things. She has not scheduled other cases on that day. She set aside a day of court time that she wants to use because I think she's going to deny the Commonwealth's motion, and she doesn't want to burn that court time and is now trying to fill that in. However, that is not the party's problem. That is the judge trying to figure out where to fill the court time. But I think that she is trying to find what they can get done on Thursday because she's not anticipating they're going to have an expert testifying Thursday. So you don't want to have essentially dead air, and you can't push the defense to do something consequential faster than they can. So just bump the hearing, Your Honor, and let the other cases fill in if you have to.
What sort of protocol you all worked out?
That's her
maybe it's in the Commonwealth's opposition that I just saw. What sort of protocol was worked out? Who was notified? What the arrangements were? How this all was set into play? And why there was a violation.
Here, let me back this up because the judge is asking the question I want to know too. I know not everyone in the chat likes the judge. It's okay. We can all have opinions about people, but I will remind you, we do not name call. And we have managed to adhere to that with people that we have very strong feelings about. It elevates all of us to be like, I don't disagree with you and I don't like your attitude. That is okay. But we can also elevate our, I do not agree with you and I don't like it. And we can still listen. And look, it elevates all of our thinking. All right. I want to hear what she's asking for because these are the things I want too. So I'm on the same page with this.
So,
not with that.
We need to come up with a scheduling order, or I've got a scheduling order that we need to discuss. But
I mean,
regarding this
we judge on the
motion, what I
inside.
need to know before I hear
We
the
just keep some of the
motion,
thoughts on the inside.
On the expert-related expenses is what sort of protocol you all worked out. Maybe it's in the Commonwealth's opposition that I just saw. What sort of protocol was worked out? Who was notified? What the arrangements were? How this all was set into play? and why there was a violation.
Fair. What the
I
fuck
can
happened?
certainly brief that for the court. We
Can you just tell us now, Alan? Just tell us now. Emily, keep working. Keep working. Keep working. So with all of that, I want to know too, like what did the prosecution tell Jackson and how did that happen? Because it shouldn't. It doesn't mean, I mean, obviously it happened. I don't think it didn't happen. But how did it happen? And I hope she gives Brennan the opportunity to expand on that, because I imagine that Brennan is also pissed that this went down with thinking, because it seems that Brennan thought that the originals were there. I don't think Brennan misrepresented that. I wonder how it was misrepresented to Brennan and what happened. So I'm curious to see. And I think the judge wants more information, fair. And Alan's like, I can just tell you now. Oh, I don't want to cover Alessi's face because it's been expressive today.
addressed it pretty significantly in our motion in terms of the conversations that were had, the expectations that we had, the protocol in terms of getting our expert out there from Arizona.
No, what the agreement was, right? People don't just show up for the other side's expert.
He said that in his
I just need to
filing.
know what steps, what the agreement was.
Like, how did we
for
get
your
here?
expert to view this on that date.
Most
He
of
said
this
that.
was reduced to email. I think it'd be
Okay, so
probably
put
a little
it-
bit more accurate for me to just go back and file a supplemental brief.
Yeah, so I need all that information.
That's fair. I'll give you the
Egregious
emails.
conduct.
Sure. Okay. I'll submit a. That won't take very long at all.
Because then we'll address this next week.
Okay. That won't take.
Sorry, it
Such
froze.
egregious conduct.
Sure.
But what the reason I backed up is because I thought the court was saying, I want to know how we end up or something of the nature with such egregious conduct. The court also does not sound happy that the defense expert showed up in Canton to download something that then didn't exist. It does not sound like the court is happy with this at all and wants them to line out to make sure that this isn't a misunderstanding and to make sure what happened. And I think it's fair of Jackson to say, let me just get you the emails. This should not have happened. It shouldn't have. And it doesn't surprise me that the court's
Okay. I'll
not
submit a-
pleased.
That won't take very long at all.
Because then we'll address this next week.
Okay. That's fine.
Damn it.
If we do not have an evidentiary Daubert hearing, do we need both days? Or
You're not having a
does it make sense
hearing.
to schedule everything for Thursday?
Yeah.
What's the Commonwealth's
She's filling the day Thursday because she's not anticipating having a Daubert hearing.
position on that?
Absent that, I don't think there are a lot of matters before the court. The motion for clarification should take probably less than 20 minutes.
Okay.
And the motion for fees is a very simple.
Can you just explain it
Discussion.
now?
So I don't think
Can you
there's
just
any way
explain
we
it?
need 2 days unless there is actually an evidentiary hearing, and then it'll take some time.
Okay. What do you say, Mr. Jackson? You're nodding?
I agree. I think if there's an evidentiary hearing, it's going to take multiple days. If there's not, I think we can pack everything into Thursday.
All right, because I don't want to waste everybody's time. I want us to get this case moving.
Of course.
So you will then file that motion to dismiss the following Monday or Tuesday, and we need to set it up for a hearing. If you are indeed filing a motion to
He's filing it.
The motion to dismiss on which Monday or Tuesday?
He's filing that motion.
after we meet next week.
Following week.
Yes. I just want to get a scheduling order going, so I need some of these dates.
Right.
Because we're going to need to schedule a hearing on that. I do not anticipate an evidentiary hearing on that, but I expect it will take time.
I don't think we're going to have an evidentiary
All
hearing.
right, so the Commonwealth
on
will have
that.
all of its discovery to you, it expects, by Wednesday, the 5th.
That's correct.
Okay.
I know this
We'll be
feels like
back
the
here at
driest
end
part of court,
next week.
but it's helpful.
After you have that discovery, I can give you until February 11th, the following Tuesday, to file a motion to dismiss.
And they've got 3 lawyers that are going to be working on that. Does that work, counsel? Counsel.
And
Does February
Commonwealth, I'll
11th
give
work?
you
I guess so.
Until the 14th
Nobody said no.
to file an opposition to the motion to dismiss. And let's hear it the following week.
What day, Your Honor?
We're also going to have to.
Can we pick a
Does the
day now
defense
so I can
anticipate any
calendar it?
evidentiary motions?
Yes, but I can't tell you exactly what those are, but in an abundance of caution, given the fact that we're expecting new information from
Yes.
the Commonwealth, I think the court can safely
All right.
say yes.
So February 21st, and I'll put this in writing.
Perfect.
Filing of all evidentiary motions, that can be an out-of-court date unless we choose that day to hear the motion to dismiss. Why don't we figure out what's your availability the week of the 17th? The 20th is actually the best day that week for us.
Robin asks, is there any way she'll approve the motion to dismiss? I want to see the motion before I give any input on that. So I want to see the motion. Judges don't like being overturned on appeal. So I want to see the strength of the motion. Because
Your Honor, that is that week is school vacation week.
Yes, it is for us,
Both Mr.
too.
Jackson and I have young children, but one of us, I think, could probably.
no, it's school vacation week for us too. My schedule aligns with y'all. Let's all just end of February. That still gives us, oh, no, it really doesn't if it's an April 1st start date. Yeah, they are running out of time because we're basically in February. They're supposed to be starting April 1st. I understand why she's so pressed. Because they need these motions done and they need that motion to dismiss done, because if they decide they want to take an appeal on that motion to dismiss, it could screw up that trial start date. Damn, it's almost March. I get it. I get when you're looking at the calendar, I get why she's like, they are running out of court days.
Probably be here on the 18th.
So.
On the 18th?
Right.
Yes, Your Honor.
Okay. Well, all right, so
Yeah,
I'd like
2
you
months
to
is
get
not a lot
me-
of time in court. In court speak,
Can the
2 months
Commonwealth get me
is
the opposition
like a week
by
and a half.
midday on the 14th? So I'll have it to review over the weekend. I know you haven't seen it, so it's hard to
214 is
figure out how
heretofore
much time
Lawnard
we
Day and Valentine's Day. It's Lawnard Love Day,
Is the
214.
Commonwealth available on the 18th?
I'm available anytime.
Okay.
Your Honor, I'm just here, whatever. The defense has a complicated schedule.
I mean, we'll put all our effort into it. If we have a problem, we could let the court know.
Okay.
We'll do our best.
Okay. All right.
So the 18th?
Okay, so the 14th will be an out-of-court filing date. The 11th, an out-of-court filing date.
Okay.
So the motion to dismiss hearing will be on Tuesday, the 18th.
All right.
Filing of all evidentiary motions will be the 21st,
Okay.
and that will be an out-of-court date.
So those are going to be your motions in limine, et cetera. Your
We will do
motions in limine.
the hearing on all evidentiary motions, March 4th and/or 5th.
Yeah. Well,
I'd like you to block off both days at this point. Mm-hmm. And if we don't need them, we'll try and, I don't want everybody coming in
no, if they don't need them, she's going to start asking about jury questionnaires and shit. The court, if you're blocking off time, the court's going to find something to do in that time.
for just one motion. I know how much work you all have to do to get ready for trial. There's a lot of work I need to do to get ready to trial, but I'd like you to block off those 2 days because we can't have motions to suppress going on and on past that date. I'm going to need some time to review them and write them. So, all right.
I mean, you could rule from the bench and then you don't have to write them.
Can
Just-
you all come back in on March 7th?
No.
We'll file all motions in limine. We'll have a final trial conference.
I mean, if they're there the 4th and 5th,
then
why
we'll
can't
have
you do
to
it on the
set up-
4th and 5th? If they're there on the 4th and 5th, can't you just do it the 4th and 5th? because they don't want to fly. Jackson seems already tired of the red eyes. All right.
A date for what I anticipate will be at least a day, maybe two, because it was last time on motions in limine. All right, so March 7th will be an in-court date.
So 3-4-3-5-3-7.
And file all motions in limine.
3-7 is one of my kids' birthdays too.
And at that time, I want you to tell me how long you expect your motions in limine to take.
We'll talk about motions in limine in a second.
Filed by the 7th. All motions in limine filed by that hearing date, the 7th.
Yes.
We'll talk about motions in limine in a minute.
On the 18th,
by
which
March
only
7th.
gives me 2 weeks to decide them.
Yeah. Well, so it sounds like the motions in
Because
limine
we're
hearing is going to
starting
be
the
the
trial on
18th.
April 1st. Jury
Yep.
Commissioner's Office has been fantastic about it, getting us as many jurors as possible. And we'll talk about impanelment, obviously, a little bit later. All right.
I do not think the court setting these dates is an
All right.
indication
Anything else we need to discuss today?
about the motion to dismiss.
Thank you.
No, thank you.
Okay. All right. Thank you all.
Facebook. I don't interpret the court setting dates as an indication on the motion to dismiss. This is very normal, necessary court process. If those dates don't get set, then there won't be dates. And those dates need to get set with the lawyers in advance. You've got lawyers flying in. You've got a lot to be done. This scheduling is necessary.
You are muted.
No, I'm not.
Bye.
No, I'm not. Not muted, not goodbye. I'm going to let everybody walk out of court real quick, and then we'll do a summary of what happened today as court wraps up, and some new dates in court. Oh, there's a lot of hearings. There's a lot of hearings to come. That April 1st date is for jury selection. Trial probably won't start for a week after that. People are chatting in court near the camera. You never know what they might say.
Yeah, I saw this and I can't delay it. Read it. So basically, just makes the record.
Oh, it sounds like AJ is talking to the reporters that are in court. That courtroom got fucking loud quick. So, I don't know who everybody is in court chat. Sorry. Can't help. But it did sound like Jackson came over to where the reporters were sitting in the jury box. All right. And with that, it got real loud. So, yeah, whenever there's a microphone, I think the assumption is that it is on and that it is on. Let's do a summary of what happened today as everyone leaves court. That looks like the very end of this motion as they are, or the very end of the court day as they are wrapping up. So let us go to a summary, and then we'll do some Q&A, and then we will get out of here because then I've got to go take care of my kiddo and swap out with Dr. B. All right. At the end of the hearing that took about a half day this morning, the court addressed numerous topics. I was pleasantly surprised that the judge actually brought up the defense's motion with regard to their expert payment or request for expert expenses. I covered that earlier this week on Tuesday. That is the motion where the defense said, Your Honor, we sent our expert all the way to Massachusetts to download the original data off of the Canton Police Department DVR system that governs all of the motion-activated cameras around the police station. And lo and behold, when we got there, there was no original data on the DVR. So our expert flew to Massachusetts and spent their time at Canton PD trying to get information out of the system, and there were no logs, there was no original data, and they refused to provide us with anything. They said it's already been provided to the defense. But then there's no metadata left with regard to that video. So the defense has said, we can't ascertain how this shit got flipped, why there are timestamps missing, because we can't see when the activation of the motion capture was activated on, activated off, how the system was working. We can't see the logs of who accessed the system and when. And we wasted our experts' time, and the defendant should not have to bear that expense when the Commonwealth told us, yeah, your expert can come out and get this information. And because you did not tell us accurately that that information was gone, we wasted our time and money. And the court asked how this happened, essentially, and said, I am wanting to understand what arrangements were made specifically for this egregious error to occur. I would be very surprised if the court does not grant that motion for costs. The court wanted more of a breakdown on what exactly was agreed between the defense and the prosecution for this to happen. The prosecutor said this seems like it'll be a pretty simple motion to address when they were talking about addressing it next week in court. The judge also seemed to indicate at the end of the meeting for a meeting, or the motion for a motion, that the court really doesn't seem to expect that there is going to be a Docket hearing. The court said, I think this is more a matter of the expert's opinion. Cue Tamara Judge. That's my opinion. The court seemed to indicate it. Yes, it seems like this is a difference of opinion. However, I am going to review the Commonwealth's argument about methodology and then have an order out by Monday at the latest. Because if there is an order that comes out by Monday at the latest, the defense has to fly their expert to Massachusetts by Thursday and get their expert there for a Docket hearing by Thursday next week. So the court seemed to me to indicate that there probably won't be a Docket hearing. I will be surprised if the judge asks the expert to come in for a Docket hearing. It seemed like the court was trying to figure out what else they would do with the court time they'd set aside on Thursday, including asking the defense if they would be ready to discuss their motion to dismiss. The defense was disinclined to acquiesce to that request and said, we need more time to file our motion to dismiss. We will be filing a motion to dismiss, but it will not be filed before Thursday. The court said be prepared to discuss it. And then the court set out other dates for things like the motions in limine, motions to suppress, and the rest of it. The defense said they're not sure exactly what they'll be filing yet because the discovery is not done from the Commonwealth. The Commonwealth indicated that they have a new accident reconstructionist, that there is a neurologist that they are waiting on a report for, that there is a new witness interview, and that there's a new report from their digital expert Hyde, and that there is another report regarding a different cell phone. So there is still more information being given from the prosecution to the defense going on into next week. So the defense said, until we have all their information, we can't do our work until they do their work, and they're getting it to us on Wednesday. And then we need that information to go forward and finish our work, our motion to dismiss, the motions in limine, any motions to suppress. The motions to suppress will be regarding mostly new information, but could be regarding old information, anything that shouldn't come in trial. And then the motions in limine will be narrowing down what evidence will come in and out, will come in or stay out at trial. And we'll see those motions in limine made. Those motions in limine, some of them are going to mirror what happened, I'm sure, at the first trial. Those motions need to be made again to preserve the issue for appeal when this trial goes forward. Some of those will probably be incorporated from the last trial. Your Honor, we made these motions in limine and we incorporate those into the record, and the court will rule what they will rule. But we might see new motions in limine with regard to new information that was turned over by the prosecution. And what we heard from the prosecution today is, look, I have been digging through this discovery to make sure the defense has everything. I went through and Bates stamped, which keeps track of every page of paper that's turned over in order, regardless of what report number it is or what page number it is. It's all stamped in order and turned over. And the prosecution said, look, I went back through, this is the new special prosecutor, Brennan. I went back through and Bates stamped everything to make sure that everything that we thought had been turned over, everything new has been turned over. And we have a way to keep track of it, which wasn't done before. And I was like, What? How do you know what hasn't been turned over if you don't have record of it? So it seems that Brennan, though I don't always agree with all of his arguments, has been trying to diligently go through all of the discovery to make sure the defense has it, which is at the minimum what should be done and should have been done before the first trial. And we've seen the defense note in several motions that things were just not turned over to them. And no matter what you think of this case, no matter what you think of the lawyers, their arguments, the judge, or any of it, at a minimum, there should be zero hide the ball in criminal court. Everything should be turned over. And it's clear from the motions that there are things that had not been turned over in a timely fashion, and that is an issue. I'm waiting to see the motions to dismiss and the response to see how much of an issue that is, but it's an issue. Things should be turned over, and there shouldn't be a guessing game over whether or not you have all of the discovery. And it seems that the new special prosecutor is playing catch up in that regard to try to make sure that it is. That's got to be incredibly frustrating for not just the new prosecutor being like, WTF is this? And for the defense being like, when are we going to be surprised that there's just something else that we didn't get? That is not how any of this process should work. So however you feel about the case, and I know there's people who think that the defense has reached beyond the sun, and there's people who think that the defense is absolutely dead bang right. It's not the defense's job to prove anything at the end of the day. It's the prosecution's job to prove their theory of the case to a jury. And did they do that in the first trial? Well, no, they didn't prove their case to the jury, as evidenced by the jury's non-decision. But you have to make sure the defense has everything. Otherwise, the consequences can be severe to the prosecution. And we saw that in the Rust case. Will this be the same situation? I don't know. I want to see what the defense has to say in their motion to dismiss. There's going to have to be a weighing of what evidence the defense is argued was not turned over and or was destroyed, including the metadata from the original video from the DVR. Could that metadata have been preserved had someone done it right? Those are things that are going to come up, I imagine, in the defense motion to dismiss that they have indicated their filing. So we've got time to see what happens ahead of this trial, and we will see. We are also still waiting to see if the Supreme Judicial Court of Massachusetts rules. They are still pending on the issue of whether or not the jury reached verdicts on 2 of the counts at the first trial. So there are a lot of things outstanding in this case. And it's really somewhat overwhelming, the amount that is still outstanding with how close they are to a retrial. Retrials are often not this busy in between the first trial and the retrial, because normally it's hey, this happened and now we're doing it again. So we've got a lot that was on the docket today. Let's see if I touched on everything, just to really, really make sure we wrap up the docket for today. The court brought up the issue of expert-related expenses and wants a little bit more briefing on that. So we will see more briefing from the defense with regard to the emails back and forth with the prosecutor. The prosecutor was notably restrained, saying we can explain. I think the prosecutor's explanation is this shouldn't have happened. I don't think we're going to see the prosecution fighting much about the expert fees. That would be my guess. Today, we saw argument regarding whether or not reporter Gretchen Voss's notes need to be turned over or redacted. It seemed to me that the court indicated some of the notes do need to be turned over, some will be redacted, and that the court reviewed those in camera and was given them this morning, which would account for why the court was running maybe 20 to 30 minutes late if the court was reviewing those before coming out. And if you hand the court something before they walk out on the bench, they're going to take time to review it. So that doesn't surprise me. Also, I'm not going to shade a judge for being late because it gives me the time I need as a buffer, because I am also always late. We also saw a brief discussion of the discovery with regard to the ARCCA experts. These are the experts hired by the federal government, not by the defense or prosecution in this case, and what discovery needs to be turned over with regard to them. That is still pending. and then the motion to either have a Daubert-Lanigan hearing or exclude, and the court's going to rule on that by Monday. So with all of that, thank you, law nerds. Let's get to your questions. I've got questions. You've got questions. We've got questions. And it's time to answer them. Also, can we just take a moment today to take a deep breath, because the technology today was so incredibly frustrating. We had a lovely sponsor today, Saily, and we had a glitch on that. So for those of you that are just coming in, I'm going to remind you that our sponsor today was Saily. They provide digital eSIMs that you can set up if you're traveling, or if you just need a second SIM for whatever reason you need. They, when I looked around the interwebs, have the best prices that I have seen on data plans. You can set that up before you travel. You can set that up more than 30 days before you go and hold on to it. So you're not scrambling at an airport with a SIM card that may or may not be valid, that may or may not work with your phone when you are already in another country and are looking for data. And it keeps you off all that sketchy Wi-Fi. And you know it's secure because it's by Nord. So I'm going to put that code up for you one more time, because I'm sure our sponsor is going to be like, technology happens, but I'm going to share that code with you one more time before we get to questions, because A, I am mortified that we had tech issues, and B, for those of you that are popping in, I want to make sure that you have that code when you need it, so that you can get everything set up before you go. So if you are ready to give Saily a try, go ahead and download the app to your phone. It is incredibly easy, and get an exclusive 15% off on Saily data plans when you use our code Emily D. Baker. That's right, just use code Emily D. Baker at checkout to get an exclusive 15% discount on Saily eSIM plans. Let's get back to today's stream. So again, thank you to Saily. Let's get to your questions, because we are going to get to your questions. Oh, my screen is doing all my things. Annalise, oh, I don't think I said that right, but I might have, but I might not have. Watching with my 16-year-old. We need Baby Law Nerd merch. Don't worry, it is on our list, but it is on our list. Do we get to things always as swiftly as we would like? No. We definitely dig through the making sure A, we can get it to everybody, and B, it will be a good quality, and C, it will not be outrageous to either ship it or to make it. It's quite a lot. Music to My Soul said, nothing gets added to the soundboard before Bloodworth's Walk the Dog letter comment this week, please. I have a list of soundboard. I'm going to have to work on it, because I need to sound balance this one, and I haven't had a chance to do that yet because it is so low. But yes, I have a list that has been waiting on Emily to do things, and that is on the list. But yes, we need, every law nerd on the internet knows, we need, it's my opinion, the soundboard's going to be a full morning show. It's going to be a full morning show by the time we are done. Patty said, this lawyer is very passionate in his delivery. Yes, he is. I get righteous indignation from Alessi in this motion today, because Alessi is like, why are we even arguing this? Why are we even fighting over this? It's clearly a matter of opinion. Alessi is not having it at all. And you could hear it. He was restrained. He was frustrated, and he was linear. He was easy for me to follow. And Brennan was arguing, I think, the factually more difficult argument of, but this has been debunked. That is proper consideration for the jury. This expert came to the wrong opinion. Great. Your experts have to express it well. I don't think this is an issue of methodology. All of the experts took the data, ran it through different programs, and came to conclusions. It is up to the Commonwealth's experts to prove why the defense expert the conclusions don't follow the evidence. That's every case where there's multiple experts. Every single one. And we've seen cases where you have multiple pathologists, and there's an argument over the manner of death. We saw that in the Murdaugh case. You have cases where there are numerous accident reconstructionists. We saw that in the Paltrow case. I think the accident happened this way. I think the accident happened that way. And then the jury decides what expert they rely on. That is for the jury. That's it. That's for the jury. So I don't think that's not what the Daubert Lanigan hearing is for. And I don't think the court will grant it. So we'll see. Peggy, I do know I just keep forgetting to sit down and update it. That's also on me. Like I say I need to do this and then other shit happens and then other shit gets done. And this week I had, not to get into all of my stuff, sick kiddo. And then I had an allergic reaction this week that also threw me off of my game. So it's just been a whole bunch of stuff. It's just been a week. We are all good. It's just, there are things that throw you off your day, but it's been constantly on my list for like the entire month. Trisha said, can you explain why some cases are dismissed for Brady violations and others are not? Yes, asterisks. There is a balancing judge determination that has to be made, and every jurisdiction is different. The facts of the case matter very much. The timing matters very much. Is it something that can be remedied with a less strict sanction? Dismissal is the most strict sanction. So the courts will look to balance, is there a way to navigate this without that strict of a sanction? Can it be remedied in some way? Sometimes that's a jury instruction. Sometimes that's more time. Sometimes it's dismissing a count and not the entire case. Sometimes it's not letting the prosecution bring in that evidence at all. But if it's Brady, it's exculpatory. So the defense generally wants to bring it in and needs to bring it in. And then is there time for the defense to still be able to use that evidence, even if it was delayed? And in a situation where we have a retrial pending, we have a situation where the defense has to argue that there is absolutely no remedy for the whatever it is. We know at a minimum it's going to involve the metadata, but for whatever else they're going to argue that there is no other remedy and there is no way it can be fixed and there's no way it can be recovered because things have been destroyed. And if there is no other possibility, that's when you get to, is dismissal the right answer? The stage of the proceedings matter very much. So did this happen during trial? Did this happen before trial? Did this happen after conviction? Or did this happen here pending new trial? And also, how much has happened in a case? What we saw in the Rust case is that there had been time after time things not turned over when the prosecution verified they turned everything over. You might have noticed in this hearing that Brennan was very careful to say, we know we're not done with discovery yet. We are still ongoing with discovery. We are still working to make sure the defense has everything. And we have not told the court they've got everything. In the Rust case, there were multiple times that we saw Carrie Morrissey say, yes, we've turned everything over. Certifying it under oath, yes, we've turned everything over. Yes, we've turned everything over. And time after time after time, it wasn't turned over. So the balancing test is part when it was turned over, what it is, if there's another remedy or not. So we will see. I can evaluate that better once I see what the defense is specifically arguing, because if there is time to remedy it, the court will not dismiss it. If it cannot be remedied because it is destroyed, then that's a different evaluation. So we will evaluate that more when we're not evaluating it in absentia with not having all that information. Also, we're gonna desk up. So chat, we're gonna stand real quick. I'm getting very wiggly. It's just been a whole day. We're gonna just shake it off together. Hold on. We're gonna go up. Chat, come with me. Come with me. If you get motion sick, I'm sorry, but come with me as we're just gonna go up real quick. We got the stand desk. Look, we got the stand desk so I wasn't sitting all day for trial, because 2025 is the year of trials. And so we got the desk so that we wouldn't be sitting all day for trials in 2025. And then I promptly wrecked my toe, so I haven't gotten to stand up nearly enough with all of you. So now there we go. Now we're here. Now we're here. We're up and away. I love it. So we'll get used to it. as we go to trial. It wiggles a little bit when it goes up, but it's just fantastic. So let's get into the rest of questions. I know I see a lot of you in the chat wearing your I Have Questions sweatshirt. It was very popular. We have a new launch. We have a new launch pending. So if you are in the Lawnerd app, don't worry, you're going to get notice. If you are a member, you will also get advance notice. So we are preparing for our next launch, and I am so excited about it. I'm so excited about it. I can't wait. I can't wait. Will I go over the defense response? Not on this live stream. I need to take care of my kiddo, who is sick. So I cannot, but will I summarize it somewhere today? Hopefully. If not, it will at a minimum be in quick bits because I do not have time to do it at the moment. Josephine said, according to Twitter, you are now part of the grifting conspiracy because you worked at the LADA's office at the same time as AJ. Okay. I mean, I told you all that AJ and I worked at the DA's office at the same time. Are we besties? No. Have we talked about this case? No. Have we talked since he left the DA's office and ran for DA and I left the DA's office? Also, no. But you know what? It's great. I know so many people that I don't actually know according to the internet. Like my life is way more exciting based on those that have decided what my life is on the internet than what my life actually is. But when I talk to people involved in the cases, I'll tell you. And which I don't want to talk to the people involved in the cases. Occasionally I'll talk to the lawyers if needed, but then I tell you guys, it's so much easier for me to just get the filings and cover them. I'm not an investigative journalist. I don't want to have conversations with people. I want to have conversations with y'all. So I just get the court filings and tell you what I think of them. So I know it's so cut and dry and boring. I know. Sometimes I agree with a lawyer. Sometimes I don't. Sometimes I like their style of presentation and still don't agree with the arguments they're making. And when we get the filings, sometimes my opinions change filing by filing. I look at, this filing and go, oh, that's pretty persuasive. And then I look at another filing and go, oh, well, that one's more persuasive. That's how it should be with filings. If you're filing something and it's not persuasive, you've not written it very well. Each filing should persuade you. It should be like a game of pickleball. Dunk, 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 dunk. And then you go, that's an interesting point. I didn't know that, because that's how advocacy works. Each side should persuade you some. Oh, that's a good point. Oh, I didn't think of that. And then at the end, you balance both. That's how that works. And then you see what comes in. And again, people want me to pick sides on this case. I saw the entire trial on this case with y'all. You know how I feel about this case? Y'all know how I feel about this case. Well, I don't think the investigation was very good. I know. Lawnerds, gird your loins. Gird your loins. I know you're shocked. The shock, the horror. I don't think this investigation was very good. I still don't think the prosecution proved their case in the first trial. I know. We got to the end of the prosecution's case and I'm like, what? I don't think the prosecution did their job to move the needle for the jury. That's period. That's it. And guess what? The jury seemed to agree that the prosecution did not prove their case beyond a reasonable doubt. That's it. They didn't. I'm sure some people have feelings beyond that about what did happen, what didn't happen. The prosecution did not prove beyond a reasonable doubt what happened to John O'Keefe. And the investigation in this case was not good. It was not good at all. John O'Keefe deserves better than that. Any victim deserves better than that. I am not really sitting here going, wow, the prosecution made a great argument on that. I exactly see how they got to that conclusion. I don't, based on what we saw on trial. Does that mean I believe everything that the defense said? No. But guess what? Does it matter? No, it doesn't. The defense doesn't have the burden of proof. It's not their job to prove anything beyond a reasonable doubt or to any standard. The defense's job is to punch holes in the prosecution's burden of proof. The prosecution bears the burden. So my focus when I look at a case is what has the prosecution proven? Or even if I might not agree, can I see where a jury could find proof beyond a reasonable doubt in a case? Do I see where a jury might see that? That's the understanding that I'm looking for. It is not the defense's job to prove or disprove anything. The defense can sit there, and I know this makes people uncomfortable. The defense can sit there and say nothing. They don't have to do an opening statement. They can reserve their opening statement. They don't have to question witnesses. I mean, they're not going to pass up that opportunity. Sometimes they do. We see the defense give no cross-examination. They don't have to cross-examine witnesses. The prosecution bears the burden. And there is a lot of discomfort in not knowing. And I know we all want answers. I look for the trials to provide answers, and I'm with you when I am as frustrated as you are that there are not clear answers. But it is the prosecution's job to provide clear answers. And I don't think in this case the prosecution has provided clear answers. And I did find some of the evidence incredibly persuasive that A, something happened to John O'Keefe, but B, it does not look like he was struck by a car based on the coroner for the prosecution, who I found persuasive. And then you get to the biomechanical engineers and you're like, something happened, but I don't think it happened the way they said it happened. And something happened is not proof beyond a reasonable doubt. So this case is difficult if you're trying to rely on, did the prosecution prove their case? And I know there's a lot of other thoughts about what might have happened here. I'm still waiting for what the prosecution is going to prove. And I don't think we've seen that from the prosecution yet. And if I do see it, I'll tell you. And if I don't see it, I'll tell you. And when I get annoyed, well, I don't need to tell you. You're definitely going to know when I'm annoyed. You can feel it. But it's their burden. And I'm not shifting that burden onto, well, the defense said this happened. It may or may not have. It's not their burden. So I'm not treating what the defense said with a beyond a reasonable doubt. And if the defense had persuaded the jury in this case, if the defense had persuaded the jury in this case, then it would have been not guilty down the line. No one moved the needle for this jury, and that's why the jury was unable to come to a decision. And there was room for argument about whether or not the jury came to a decision on 2 of the counts. We're waiting for the Supreme Court to see if we can dive into that more. But if the defense had been persuasive, then we would also have seen the jury come back and be like, nope, not guilty. So we are in the middle, and waiting is deeply uncomfortable because we want to know what happened. And we want to know what happened through court process that is proper and untainted. And we're waiting for that in this case, or at least I am waiting for that in this case. And I'm glad to hear that the prosecution maybe brought in another accident reconstructionist. I don't know what they're going to say, but we'll see. This case is frustrating. It is. It's incredibly frustrating. And we're going to keep watching it. So that's where I'm at. But I'm glad to know that, it's okay. Pick a different case, and I'm way too prosecution oriented. Pick this case, I'm too defense oriented. It's fine. Generally, both sides that have strong feelings are mad at me when I cover a given case because I am here to see where the evidence leads us, and I have gotten comfortable in waiting for the facts to come out. I get more frustrated when we get to the end of a case and I'm like, what the fuck has happened here? But I have had a lot of practice at that. And not everybody has had a lot of practice at that, but I've had a lot of practice on that. And so it's my goal to wait and see. By the time we get to end of trial, I generally have feelings, which I think almost everybody does by the time we get to an end of trial. We got to the end of Sarah Boone. I was like, oh, the defense made some errors in bringing in that defense. Welp. Wow. But it should change. And it should feel like, oh, how are they going to disprove that? And then you get into the next part of the case and you're like, oh, those are really good questions. And then you get into the rebuttal and you're like, oh, I didn't even think of that. That's how it should go. Back and forth and back and forth and back and forth. And you just try to keep an open mind and say, oh, I feel this way, but I'm open to hearing what you have to say. The thing that's really special about the Law Nerds is how open to hearing what both sides have to say, even when you have opinions and thoughts and feelings about a case. It's when people aren't open to hearing and continuing to ask questions that they get real mad. But that's not our community, so I don't really worry about it. But I'm glad to know that in this case, I'm too defense friendly as opposed to being too prosecution friendly and whatever else anybody's going to say. I talk about things on the internet. That's what's going to happen. Froggy Girl asked, do you think the Commonwealth is doing this to get a deposition without calling it a deposition? Sounds like they want to get into it before trial. Well, they have a full transcript of it. I think that the prosecution is trying to narrow down what did he say? Salacious statements come in. I don't think he's going to get to do that. So I think the prosecution is making the motions they feel they need to make, just like in other cases, the defense is making the motions they feel they need to make. And you look at the motion and go, that's not going to happen. But they make the motions because they need to. And this was something that wasn't explored on the last trial. Lally didn't make these motions. Brennan is going to. So that's where we're at. Rachie, thank you. Rachie said, the way EDB covers each case helps me understand more about each case. I think what most lawyers do well is look at both sides of a thing. This side's going to argue this. This side's going to argue that. This side's going to say this. This side's going to say that. And you really have to be able to have that argument with yourself back and forth so you can make the best argument for your side. I like getting to be here going, they're going to do this, they're going to do that, they're going to do this, they're going to do that, and evaluating the back and forth of a thing. Because I don't see myself in doing this as an advocate. I see my role doing this as someone who's here to help explain. Like, I'm more of a guide to what we're watching through how I take the legal proceedings, my background in court work, and my experience. And then sometimes just because it's entertaining, it's like, well, I'm entertained by this argument. I don't know if it's going to go anywhere, but I am amused. So I really treat it much more like I treated my work as a research attorney than as an advocate. As a research attorney, it wasn't my job to advocate. It was my job to distill and explain what both sides were saying, look at the law, and then say, this side has a better argument under the law. And sometimes the law and the feelings, or the law and the morality, don't line up. And you go, this seems like the wrong result, but this is the legally right result, but it feels like the wrong result. And I don't like the result, but this is legally the proper result. And that happens all the time when we get legally proper results that don't sit well. But that is the law. And it's like, I don't like it, but that's what's right legally, not morally. The Dash in Between with Matt Bond. Good to see you. Hello, my spiffy legal mumbo jumbo talkie sister from another mister. It appears everyone is still using my hashtag OnlyFan. They are, Matt Bond. They are, at least in Massachusetts, because in Utah, we just got carpet. Utah doesn't seem to have a fan. And that is, well, what it is. Lori and CT said, my observation after the first trial after ARCCA testified was EDB, Peter, Runkle, and Rob were expecting an acquittal, and that's why the jury was taking so long. The ARCCA experts I found to be very dispositive. I can understand where the jury took so long on count 2. It was not explained well, But when it got into like 3 days, I'm like, oh, they're not deciding. They're not deciding. But the ARCCA experts I found to be incredibly persuasive and logical. So, but the jury could not agree on that and could not agree with that count two and all of the subsequent lesser included counts. It's confusing. And I think I commented, if I remember, I think I commented at the time that the parties needed to explain the lesser includeds in their closing, and neither party did. And then when the jury was getting confused, I was like, yep. Crooker, thank you for the 5 gifted memberships and everyone who gifted memberships. Rachie in the chat said, I get so confused when Legacy Media covers the same stuff that EDB covered. A lot of their stuff, in my opinion, seems one-sided. And again, that can be the case. Not everybody just writes about both sides. I just wish they would disclose, I think this. Like, if it's opinion, tell you. When it's my opinion, you're gonna hear it. So, but we will see what happens with this one, because we will see. The real Melon Lord said, what did the policeman say to his shirt? You are under a vest. It's very true. It's very true. And thank you. Niners Girl said, I didn't have lubricant on my bingo card. Yeah, we did not have lubricant on the bingo card for today in court, but I don't think we heard Orwellian or dystopian today in court. We did get some incredible use of language in court today. We really did have some moments with the lawyers, but yes, we did not. The other thing I will say about Legacy Media is oftentimes the Legacy Media is trying to explain legal documents more broadly without the nuance. And you get things like everybody reporting on something because everyone else is reporting it, but the source material, like so often I see one outlet report a thing and then every other outlet reports the thing, citing back to the one outlet. Nobody goes to like the source material. Like, are you all not reading Fourth Wing? Find a primary source, people. It's just, what are we doing? But they go back to the first outlet. They don't go back to that outlet's primary source. And then whatever that outlet said, everybody just runs with and is like, oh, this is our thought on that outlet reviewing this legal document and saying this thing. And then they all get it wrong. And you're just like, did anyone read this other than us? No? Okay. Yeah, we had flummoxed today. We did get to myopic. We did. Alessi was letting it fly. So it is hard sometimes for me when I'm reading it, just being like, wrong. I'll just pull up the lawsuits or the filings and go through them with y'all so you can see it for yourself. And then even if you disagree with how I interpret something, at least we've talked about what the filings say. We can disagree if we think it's a strong filing, not a strong filing, a good argument, not a good argument, if they have a point, if they don't have a point, if they're reaching, if it's well taken. But at least we all know what the thing says, which is what's so frustrating. Oh, Matt Bond, I'm sorry that you're sick. I'm sorry that you're in the ICU. So many of you are. The flu has been going around and it has been wild. Hillary said, EDB, you've ruined me. Hillary, I'm so sorry. Was watching some of the cabinet hearings, and every time they questioned folks like Kash Patel and mentioned it, my brain screamed, the FBI! The FBI! I know. It's an earworm, and again, this sound clip I grabbed from the Kevin and Bean show because I grew up listening to the world famous KROQ in the 90s, and it sticks in my head too. So every time they say the FBI, my brain goes to that. So now all of you get to join me in it. KK in the chat asked, what is in camera when the judge says that? The judge means that the judge will review it alone in chambers. So it is a judge-only review. It is for the judge's private review in camera. I don't actually know the origin of the word in camera. I wonder if it would be in my Black's Law Dictionary. Hold on. You've made me nerd. I wonder if it has the origin of why it's called in camera, because I know what it means, but I don't know the origin. Hold on. We got the old Black's Law Dictionary. Ugh. Let's see, shall we? Let us see. Let us see. I got a new Black's Law Dictionary, but I need to like move over my tabs. I know. Let's just check together, shall we? Because I wonder if it'll give us the derivation of the word. I don't know. Maybe it will. Let's see. I'm curious now. And then, Emily, you said you needed to go, and now we're on a side quest into a dictionary. Yes. Yes, we are. All right, we should be getting close. Let's see. Emily, how do you alphabetize things when you can't see the letters in your head? Not well, everybody, not well. So it's going to take me a second. All right. In camera. Did they give it to us? Let's see. Becky R asked, why is Black's Law red? I don't know. Black's is the original author, last name. This is a 7th edition. I just got a new one. Have I even unboxed it yet? Emily, oh my God, speak less like a YouTuber. It's around here somewhere, but it's not on my shelves because I didn't have room for it because I needed to rearrange the shelves. The shelves are in the middle of a redo. And then my toe got attacked and then everything went sideways. But I have a new, this one's old. This is my law school one. I have my old Black's Law Dictionary. But I got an updated version because new stuff happens. All right. It literally means in chamber in Latin. Ha-ha! Thanks, Black Law. In camera means in Latin, in a chamber. In the judge's private chambers, in the courtroom, with all spectators excluded, or of a judicial action taken when the court is not in session, also termed in reference to the opinion of one judge, meaning in chambers. So in camera references in a chamber, literally the translation from Latin. So yay. Thanks, Black's Law. That's the derivation. Literally in chambers. Which I think is the definition I gave, but I'm glad to know that now we know the full. That was probably, KK, more explanation than you ever wanted. I'm sorry. Sometimes that's how those answers go. Sarah said if she is convicted and the federal grand jury concludes that it didn't happen that way, can she be released? This is an incredibly fact-specific question, Sarah. There are a lot of possibilities for what could happen if the result in trial and the result in a federal grand jury are somehow different. And that is why it is incredibly rare that we see things going forward at the same time. Are there possibilities that whatever's decided by a grand jury could lead to a future appeal that could lead to a conviction being overturned? Yes. If a grand jury decides a different thing, does it automatically mean that would immediately happen? Like if? No. It would be a jumping off point for more process. And there would be more process. To everyone who gifted memberships, thank you. We are going to be doing more members onlys next month. So that's going to happen. Brittany said, are you allowed to argue this is bad for my case? I mean, don't we see those objections? Sometimes they're objecting and you're just like, oh, objection. This is bad for me, Your Honor. This is bad for me. A couple of you asked in the chat, is Emily, wrong case. That's where my brain went to that case when I was talking about objection. This is bad for my case. Is Karen Reed in custody? No, Karen Reed has been out of custody. She was only briefly in custody when arrested and arraigned, but no, she is not in custody. Jane, does discovery ever close? Yes, there is supposed to be a cutoff, but if things are later discovered, they need to be turned over immediately. So yes, but yes, there is supposed to be a cutoff. That cutoff can be more firm in civil cases, but in criminal, even if the prosecution sees something that like law enforcement had, this is where this comes up most often, sees what law enforcement has in their file that they never had. So if the prosecution never got a report from law enforcement, it can happen that they get that after all discovery they think is turned over. And then they've got to go to the defense and be like, here, this should have been turned over. We didn't know it existed. Law enforcement had it. We just got it. You just got it. And now we need to go to court and deal with what happens because it was late. So yes. And there's also ongoing discovery. So Even if discovery stops and the prosecution gets something, they still have to turn it over. That could even be a witness calling law enforcement and being like, yo, this happened. And it's like, well, we thought discovery was done and then this witness said shit. Here's the shit they said. So the prosecution always has to turn over, whether trial's done or not. Rebecca Wrights said, the Commonwealth is saying the car was essentially the murder weapon, yet now the evidence is gone, no proper chain of custody with the video as it's been tampered with. We'll see what the court says about tampered with. How is all of this okay? And the case still moving forward. The defense hasn't brought their motion to dismiss yet. Doesn't mean that it's all okay. And we'll evaluate what happens with regard to the video and the metadata. And we'll see. Question, EDB, how should we go about not being frustrated with the judge? No, I think there's room to be frustrated and then still listen to what the judge has to say. Trying to put aside frustration can be difficult, but doesn't feel super even, but I don't want it to shadow me during the next trial. Thanks. AK, I think knowing that you're frustrated with the judge and still trying to listen to when is the judge being fair, it's hard because with frustration with the judge, a lot of people think the judge is completely one-sided. I have not always seen that. This judge has been short at times for sure. I have also seen the judge give the defense time to make their record, but there's times I've seen the judge not give the defense time to make their record and go back and forth. So we'll see what happens, but the whole case is frustrating and it's hard to put that frustration aside. And I didn't watch all of the pretrial before the first trial, so I didn't come in as frustrated as many are who have been following this case for longer. And that's just earned frustration from watching this case from the beginning. So I get it. I try to explain what's happening and how I see it and put the feelings aside, but I'm also used to separating the feelings out because lawyer, and there are times when you just have to. But it's really acknowledging like, oh, I feel this way. Let's just see what happens. And then you have to judge each thing on its own instead of as a accumulation, which can be hard. Sharon said, EDB, what is meant by out of court date, please? Sharon, not even needing a please. Happy to answer the question. It just means that it's not a date for them to be in court. It's a filing date. It's a deadline. It's a deadline on a paper, not an in-class presentation. So the in-court is everybody come into court, we're doing things. The out-of-court date is this is your deadline to turn in your papers. Hopefully that helps. Just because says, is she setting this up to be appealable? If we're talking she, Karen Reed, the defense is always trying to make every objection they can to preserve them from appeal. If she references back to the judge, no, judges do not like being overturned on appeal. They try to do things linearly and not strange so that they don't get overturned. Judges want to follow the precedent that's gone before. Becca Doug said, hey, Emily, so excited to catch a live. Hi, my twin sister Rachel is watching across town. Will you shout her out, please? Hi, Rachel. Becca wants to say hello. Hope you are enjoying watching across town. Hope you guys are getting to chat back and forth. Nishay, I did see that filing. I will grab it. I don't know if we'll do it for quick bits or not. I know that there are other cases here or other filings today. I will grab them and we will summarize them either in quick bits or elsewhere. Music to my soul said the judge is really giving me the impression she's eager to hurry up and deny the defense's motion to dismiss. That's not the sense I got from that. The sense I got from that was that's a serious motion. They are very close in time to going to trial when you look at actual court days. And the court, I think, is really indicating administratively that like we are running out of days to do these motions and we need the defense knows it's coming. We know it's coming and we need to do that because that's going to need a full day of a hearing and there aren't that many days left between now and trial. So I know it feels like 2 months is not quick, but in court time, 2 months is fast and that will come up quickly. And the judge does not want to have to bounce back when the jury comes in because they're already working on getting jurors. They don't want to lose jurors because they don't start on time. They don't want to lose court space because they don't start on time. And so some of those are administrative decisions and they are getting into the difficult part. This is not like the last 2 minutes of a football game where 2 minutes take 117 years. This is a rugby game where there's no stopping the clock, and it's a lot. So it's a lot. Let's see. Family has a condo in Deer Valley. I want to go. Deer Valley. The ski resort sounds amazing. Deer Creek, the concert venue, also amazing. So all of you, law nerds, I know we didn't get to everything. I'm sorry that we didn't get to everything. I'm going to try to get to just a handful more questions, and then we're going to Zoom. But OG Sean White said, as a resident of Massachusetts, and the fact that I live 2 towns away from Canton, I feel this is a gross misuse of taxpayer dollars. These hearings are a waste, and the retrial is a waste. The DA in this jurisdiction is elected. You can always let your elected officials know how you feel. There's official process for that. Most offices have emails where you can officially email and lodge your complaints. Same with like your state's attorney general. I appreciate that process. I do not, you know how I feel about people going real world, but you can make your elected officials aware how you feel. Hey, why are we doing this? All of these things indicate to me that this is not a good use of our resources. Have we nothing else to do? Is there not a pothole somewhere that needs filling? Why are we doing this? They do take those seriously. Generally, elected officials, if they receive one email, they have, depending on the office, quite a lot of thoughts about, if I've received one email, there are probably dozens, if not hundreds, depending on where you are, that also share this feeling. So you can let it be known. I'm sure people have let DA Morrissey's office know. I think they are aware in this case, particularly how people feel. Lindsay 902 said testing VPN might have been the problem with Super Chats not sending and unable to get memberships. Well, I see this one, and sometimes VPNs do that. VPNs are like, no, I've got you. Don't worry. Don't do that. Sapel said, just turning in, but his delivery reminds me of Lally. I have found both of the attorneys arguing today more direct, and I appreciate that they have been more direct. Today's been a day, Emily, but all-dressed chips for breakfast don't sound terrible to me. I like all-dressed chips a lot. So Steve said, Whiffen didn't like the interpretation of the data and literally removed the feature. Who's his customer that he is trying to appease? Law enforcement seems a bit fishy. And I think all of those would be great points for cross-examination of Whiffen, because Whiffen's not like the head of Celebrate, but I think it's worth asking a question of Celebrate. Why did you change that? Because I think the other side of that argument from the prosecution will be, and from Celebrate, I think will be, and again, I think this is their argument. Their argument will likely be, this was misinterpreted, and we want to make sure it's clear so this misinterpretation can't happen in the future. What the defense expert's going to say is, no, there's no misinterpretation. This is what the artifacts say, and this is how we interpret it, and these other softwares show it. So that's what the arguments are going to be there. But that is all a perfect question for cross-examination. And you can see AJ saying, who uses Celebrate the most? How do they access Celebrate? Do you only sell Celebrate or allow access to Celebrate to law enforcement? Are there private uses for Celebrate? How do people access it? Do you have to be registered? I think those are all very good questions, for sure. So, Ray, when will you be restocking the purple hoodies? These purple hoodies are not being restocked. When we sold this launch, it was our first launch with Law Nerd Shop 2.0, and not everything in Law Nerd Shop 2.0 is going to be evergreen based on a whole lot of different factors. But we have a new launch coming up soon, which is one of the reasons I think the members are so excited that they get early access to things, because we do have things that will sell out and will not be restocked. Might we be able to do that way down the road? Maybe, but not. It's not on the docket for the shop for the next 9 months. So the purple was a limited run, and that is different than Law Nerd Shop 1.0. So Jennifer, you're going to have to wait. But we've had lots of requests for them. Lots of requests for them. Lots of requests for zip-ups. So you're going to have to wait and see. No, just a wink, no spoilers. Just a wink, no spoilers. But don't worry, we're going to keep you in the loop for it. So Becca was asking, is the special prosecutor or defense? Oh, I don't know what time we were arguing, but we have a new defense attorney and the special prosecutor. So they were both, I'm sure the chat answered. So chat, it is good to see you. Don't forget to get the Law Nerd app, because that is how you're going to stay in the loop with everything that's happening. I'm going to have to take a look at what they're doing next week. I am going to take, do not tell Team Baker. Chris, stop listening now. Just pause. I am going to take a mobile streaming setup with me in case we need to go to court next week. I'm going to take it with me. We might need to go to court next week. And if a lot of you get the app and really want us to go to court, I might be persuaded. I cannot tell you what stage of awakeness I will be in on Thursday next week. But I am going to take my mobile streaming and we will see. We will see. But get the Law Nerd app. I am not supposed to be streaming next week. I was going to be off the entire week. I am traveling. And we will see what happens. We might just have to. So I will take it with me. There will be a new Quick Bits for you on Monday, and the Law Nerd app keeps you in the loop so you don't have to remember what channel things go up on. We just tell you in the Law Nerd app, and then you can just click it and watch it. So we will be back Monday with a Quick Bits. Members, I will let you know when I'm recording. It's going to depend on what happens at my house with my family and everybody feeling well or not today. So I don't know if that will be today or tomorrow. I'll let you know in all of the member places. And Quick Bits Monday. I may or may not be streaming next week. I make no promises. I will take a look at what was filed today and try to give you a summary or at least like a 3-minute breakdown on Quick Bits. I will do my best. It's just going to depend on family today. So Law Nerds, thank you for being here. Thank you for being a Law Nerd. Thank you for going to court with me. You know it's one of my favorite things to do with you all. We have so much court to happen. There have been so many filings. We've been like Diddy Who on this channel for a couple of weeks. I mean, we all needed a little bit of a break. Honestly, we all did. And there's filings in that case. There's more going on in everything else we are covering. We're going to share in the Law Nerd app where you can find me on ABC, giving my thoughts. Have I had a chance to watch it yet? No, but if you find me on ABC Hulu's Impact, I am there with some of your other favorites from around the internet. Have I watched it yet? No. Hopefully the chins look good. We're just vanity. It's about vanity. The lighting looks good. We hope we don't look as tired as we are today, but one never knows. I filmed that when it was like 5 degrees in Nashville and my hair was like, but it happens. So I will be putting a link to that in the Law Nerd app for y'all today. If you take a look at Impact, I will put up a chat in our Law Nerd Lounge so we can talk about it and give you some behind the scenes. And with that, Law Nerds, if you're interested, lawnerdlounge.com. Law Nerd app will get you to our app so I can keep you in the loop. Law Nerd app is free. Law Nerd Lounge is not. Law Nerds, get the app. I'll keep you in the loop for next week. And I will see you soon. Thank you for being here. Thank you for being a Law Nerd. Take care of yourselves. See you. Thank you for joining me. Make sure you don't miss a live stream or any of the updates on the cases that you care about most with the Law Nerd app at lawnerdapp.com. It's a free download on iOS and Android so I can keep you in the loop, because you never know when something's going to pop off. Thanks for being here, and thanks for being a Law Nerd.